What is everybody? Welcome back. Truth and Transparency. Today's the day, May 13th, 2026. Shanna Gardner in the courtroom for a suppression hearing. We've been waiting for this for a while. We've had a lot of pushbacks in this case due to discovery issues by the state. We've also had lots of depositions in the state of Florida. This is where the case happens in the state of Florida. Jacksonville Beach was the murder of Jared Bridegan. Jared Bridegan was married to Shanna Gardner from, in the early 2000s. They get divorced in 2015. This murder for hire is allegedly said to have happened February 16th, 2022. That is when Jared Bridegan was ambushed after dropping off the twins, who he shared with Shanna Gardner on a Wednesday at just about before 7:45 p.m. Dropped off the twins, had his other daughter from a new marriage in the backseat in a rear seating car seat. She was 2.5 at the time. Driving up about 5 minutes from dropping off the twins, an ambush happens. 4 shots ring out. A couple of them heard on a Ring camera. A whole year would go by. 6 months. And a man by the name of Henry Tenen, nobody knew at the time, Henry Tenen was arrested off of a traffic violation, a ruse, in August of 2022. Then all of a sudden, January of 2023 comes about, and the attorneys announce that they are arresting, while he was arrested, Henry Tenen for his actions in the murder of Jared Bridegan. There was a big press conference. At that time, wiretappings would occur. Google search warrants, iPhone search warrants, and iCloud search warrants would go out January, February of 2023 on Shanna Gardner's devices. This suppression hearing will cover Shanna Gardner's iPhone, her iCloud, her Google account, and a couple wiretappings. Now, there was 2 different rounds of search warrants that were obtained in this case. There were ones that were right after the murder of Jared Bridegan in 2022, April of 2022, of Mario Fernandez, which was Shanna Gardner's new husband, and of her cell phone in 2022, again, April. And then it would not be until January, February, March, April of the next year, 2023, that a round of those new search warrants would go out. And that is what is being sought out to be suppressed. Now, this is going to be some amazing legal arguments. Henry Tenen, I actually just ended up watching it. Henry Tenen was just in the courtroom. They pushed him back to start at like 11. Okay. Didn't tell anybody. They said that they were going to start him at 9. Okay. So what I want to do here is I'm going to play a little clip just to get people, hey, here.
Welcome back to Long Crime Daily, everybody. We have a big update for you in the death of a Florida Microsoft executive targeted in a hit last year. His ex-wife is now facing charges. So we want to lay out all the players that are involved in this. So Jared Bridegan was married to Shanna Gardner, but the two divorced. Shanna married Mario Saldana Fernandez. And investigators say that Fernandez plotted with a man named Henry Tenen to kill Bridegan. Tenen was a tenant at one of Fernandez's rental properties, and when he was arrested, he admitted what he'd done and told police that he would cooperate with them. Police say Jared Bridegan had just dropped off his twins at Shanna's home in Jacksonville Beach, Florida, and he was headed back to his own place with his 2-year-old from his second marriage in the car when he came across a tire in the road. When he got out to move it, police say Tenen shot him. Shanna moved across the country to Washington after the murder, distancing herself from her new husband. But Thursday morning, a grand jury handed down an indictment against her. Prosecutors also made a stunning announcement about punishment they're seeking.
This morning, a Fourth Circuit grand jury indicted Shanna Gardner for first-degree murder, conspiracy to commit first-degree murder, solicitation to commit first-degree murder, and child abuse, all related to the murder of Jared Brightigan, Shanna's ex-husband. Gardner was arrested shortly after and taken into custody by ATF Washington Field Division agents in West Richland, Washington. Gardner will be extradited to Duval County to face these charges. We will be filing a notice of our intent to seek the death penalty, as we have also done in the case of Mario Fernandez.
Okay, so the prosecution's now seeking the death penalty against Gardner.
Okay, the death penalty has gotten tossed. Okay, Henry Tenen has recanted. In fact, the oral arguments this morning were so interesting to me, and I want to know your guys' opinion. So this gets underway here. We have about 25 minutes. Okay. And the question is for Henry Tenen, why he was in the courtroom this morning, is Henry Tenen was doing plea negotiations. And during plea negotiations, anything that you can say, you either have to have your Miranda read to you. Okay. You're advised of your rights. Okay. So if you're usually in plea negotiations, it's a disclosure that none of this can be used against you. Okay. It's kind of like if you've ever been through a divorce, usually if you have like settlement conversations and stuff like that, none of that can be used if you were to go then to trial and have your divorce proceeding, heard out. No different here, that there is a process. So if you're going to be, hey, we want you to work with us, this is a negotiation. The issue is that the state wants to use what Henry Tenen said to basically, if you want to say investigators, or if you want to say the prosecution team, they want to use that against him in a courtroom at his trial. So everybody's going to have their own trial. Shanna Gardner's being tried separately. Mario Saldana's being tried separately. And then Henry Tenen is now going to be tried separately. What this plea negotiation was, and I think it's just best, I think that this woman, Julie Schlacks, I'm so excited for you guys to see her. She has energy, and she's actually fighting for his rights, number one. Number two, they call Alan Chipperfield to the stand in this hearing this morning. And she does such a good job of getting him to say on the stand that when you have these negotiations with your client, okay, did anybody say like these can be used against you? They can't be used against you? Like was this part of the plea deal because they didn't sign until a certain date? And then get this, just because we have a deal, the courts have to sign off on it. And until the courts sign off on it, like, where are we? That type of stuff usually happens. Usually get the court's permission for shit like that before you offer somebody even a deal. Like I said, everything about this case was done ass backwards. Why? Because there is the way that they developed this case foundationally sucks. Okay. And when you foundationally have a case that sucks, when the top is too heavy and the bottom can't support it, it's all going to collapse. It's like the house of cards are coming all down. That's why I said earlier this morning, I was like, man, I think Judge Kite's going to have a lot of she's going to have to make some serious decisions. So here in speaking with, let's show you guys a little clip of this morning. Here is there's Henry.
As compliance with it as a
Okay.
Was that Swartz?
So this is Alan Chipperfield.
state attorneys present. There was the detective. He was not present. Right? If you need to refer your.
Well, I know that he was present at one of our meetings. I'd have to look at my notes to see if he was present on that day.
Okay. Well, and correct me if I'm wrong, he was present, and I'll concede with defense agreement that he was present because we say he's present on 3/15 of 2023.
Yes.
The time of the sworn statement.
Yes, he was there.
And so that was the time that you were thinking about? That he was present?
This calls for a range of potential sentence, correct?
Yes, with the bottom being 15 years, no less than 15, up to life.
And meaning that the sentence was very much open, including whatever recommendation the state may ultimately give.
Right.
And those terms were still up in the air, if you will.
Well, yeah, we didn't know at that point what the victim's family was going to ask for or recommend. I didn't know at that point what the state was going to recommend. All we knew was it was going to be at least 15 years. And the other terms that are stated here, that he has to testify truthfully.
Thank you. I don't have anything else, Your Honor.
Okay. All right. Thank you, Mr. Chippewa.
Sure.
And now check this out.
Did the state have anything further, or were there any other, I guess, scheduling concerns?
Okay. So here she's going to give an oral argument.
Okay. Ms. Schlax, it's your motion, so I'll hear you first.
Certainly. Your Honor, as articulated in the motion, and I provided to the court hard copies of the individual cases that I had cited previously in my motion, and I'm happy just to run through those very briefly.
Okay.
Because I would argue to the court that the law in this area is somewhat clear in that the Robertson test, as enunciated by the Supreme Court of the United States, has actually been carried through, and that is a two-part or a two-prong test. And essentially, it's whether the defendant subjectively expected to negotiate a plea, and two, whether that expectation was reasonable under the circumstances. And I would argue to the court that the appellate decisions by various Florida courts, including the Supreme Court, have seemed to turn on whether the agreement was fully completed or whether it was still ongoing. And that is a key factual scenario.
Okay. Now, this is what disgusts me. Okay. Obviously, this is a plea negotiation. They're going back and forth, right? He has to say certain things, right, in order to get this plea deal. And one of those things is to even testify truthfully. They end up putting Henry Tennant on the stand here today. Okay. He doesn't know what the fuck is going on. I can't even understand his answers. Okay. And because all of this is about the state of mind of him, what did he think this meant? You know? It's like this. I would be nervous to say on the stand, well, my lawyer just told me that I needed to do this, this, and this, and say this, this, and this. And, you know, like you're scared to tell anybody anything because you're like, holy shit, I don't want to say the wrong thing. I don't know what, I just don't know. Okay. And so the state over here, it's like, you guys know what y'all did. He didn't know anything about the case. He didn't know anything about the murder. And it's supposed to be that was he told that anything can be used against him? Was this deal over with? And so his statements that were then afterwards, they can't use again. What's going on here? And I think she did a good job of.
I'm going to start with the cases that I imagine the state would start with in regards to they tend to support their argument more, which is Groover and Wainwright. But what is so critical, and I think what turns decision. Additionally, in Nunes v. State, spelled Nunes v. State, another 2008 decision from the Florida 2nd District Court of Appeal. And this was a robbery, arson, and murder case. And in fact, after police contacted him, he and his lawyers met with prosecutors. During that meeting, he gave a recorded statement admitting involvement, expecting cooperation might lead to favorable treatment. Ultimately, the court held that statements made while a defendant reasonably believes they are negotiating a plea are inadmissible. And again, citing the Robertson two-tier test, in that situation, the defendant himself subjectively expected that he was in plea negotiations, and that was reasonable under the facts of the case.
Okay. How can, if the judge has not signed off on the case and accepted the plea, okay, and sentenced him, kept him out of a courtroom for how long, okay? How could it not still be in a plea deal? Especially when it's just so much is up in the air with, I mean, usually in a plea deal, it's like an exchange for something and like X, Y, and Z. I just think in this case, I would have tried to argue the fact that how can the state make Henry Tennant testify truthfully when they know his testimony is false when they accepted it? Where's that case law? Where's that case law that testified truthfully? What? How you want him to testify? Is that truthfully? Is that what truthfully means? He's going to testify against these two? Like, what? If the state knows, because they have knowledge, they possess this knowledge. I'm sorry, and they know that Henry Tennant is not the shooter. Okay? And so what? That just doesn't matter?
In regards to State v. Guzman, Mr. Guzman, and this is a 3rd District Court of Appeal case from 2008, Mr. Guzman made incriminating statements during a polygraph examination. That polygraph examination was agreed to by his lawyers as well as prosecutors because they were attempting to negotiate the case. Ultimately, the court had no problem finding that the statements made during the polygraph examinations were connected to the plea negotiations and were therefore admissible. This can be contrasted with the factual scenario of Wainwright. In Wainwright, Your Honor,
of a plea of guilty or statements to negotiate.
he thinks he's making some kind of an agreement until he's physically before a judge the next to his interview tape. He was specifically told in February 2023, the only time it suggested anything in regards to his right to remain silent or make any kind of statements, that those statements would not be used against him. Your Honor, I would argue to the court that subjectively, of course, that is the only time that he is told anything, contrasted to his interview tape. Before he was questioned by law enforcement, he was read his constitutional rights. No such thing occurred. Was it objectively reasonable based on all the circumstances? Mr. Tennant is brought physically to the state attorney's office. He does not control if he's brought over. His lawyers are there. He's then asked questions. He thinks he's making some kind of an agreement until he's physically before a judge the next day, and that plea is accepted and ratified by the court. Is that plea complete? The state of Florida could have immediately after the entry of that plea, once it was finalized, said, Mr. Tennant, please come over. We need to go through all of these details and secure your actual testimony. That would have been in performance. Never elected to do that. They only obtained statements from Mr. Tennant when he was under the mistaken belief that he was in full plea negotiations. And I argue.
You understand that? So, and then here at the end, she says, because the state's argument is that we don't have to warn him every time that, hey, this can be used against you. Hey, this can be used against you. Okay. And her argument, I think it's fabulous here at the end.
Simply statements proceedings case, and we'd be in an entirely different posture. Had they elected at any time after March 16th, 2023, when that plea was fully accepted and ratified by the court and was a binding plea agreement, they could have asked Mr. Tennant to come over to the state attorney's office. They could have demanded that Mr. Tennant come over to the state attorney's office and ask him whatever that they please. And at that point, I agree. I would be stuck with this is simply statements in furtherance of the plea. That's not what occurred here. There were too many things that were unknown. He had a subjective belief that it was not final until the court would ratify it, and that the state would actually present it with, again, victim approval. He did not know that. He was never told. All of these statements that you're saying, hey, if something goes wrong with this plea, if we decide we're not going to fund it, if you decide you're going to withdraw it, nothing was ever said, and how easy that would have been. There's a reason that every detective is taught upon sitting down with a suspect that they are going to read them their constitutional rights. The state of Florida elected not to do that, furthering his objective belief that in fact this was all pursuant to his plea negotiation that he was continually trying to do. And so we respectfully request the court to grant the motion to include any private statements by Mr. Tennant to the entry of his physical plea. Somehow we have changed the standard that we have always adhered to, in that now instead of advising someone who's accused of a crime that they have the right to remain silent in anything they say, now we're putting the standard that supposedly Mr. Tennant should have asked that question.
Yes, I love it. Hell yeah, Julie Schlack. Right there at the end, she says, let me get this straight. We're going to now change the standard, which is because Maserati gets up there and he's like, Mr. Tennant could have asked at any time. Mr. Tennant had his lawyer there. He could have asked at any time, like any of these questions, and he didn't. That ain't the standard. And Mr. Maharahi over here can fucking kiss my ass. Okay. So the standard is we do what as police officers?
And again, the state of Florida had a number of options too, in that now instead of advising someone who's accused of a crime that they have the right to remain silent in anything they say, now we're putting the standard that supposedly Mr. Tennant should have asked that question.
Dude, it was so great. You got to give it up for Julie. Julie's putting in motion after motion after motion. She is asked for a crime scene specialist, reenactment specialist. She's asked for a PI. She's asked for she needed DNA testing. She's putting order after order after order, or motion after motion after motion, and Kite is granting it like day of next day. Boom, boom, boom. Okay. She's filing depositions. She's been attending these depositions that Shanna Gardner and them had already set up. Just bottom line is should they be able to use anything that Henry Tennant said in this plea negotiation against him? And the answer is fuck no. Absolutely not. Absolutely not. And I hope that if Judge Kite doesn't rule in Julie's favor, that she goes and appeals it to the higher courts. Okay, because let me get my Henry Tennant new binder out for a second. Remember, guys, we're in front of the courtroom here in 7 minutes. Let's see. Shanna Gardner, let's see if her lawyers are out there. First Coast, Jackson. Let's get her going. Let's get her going. Let's get this. Let me see. Let me see 1 second. New Henry filings. This lovely new binder here. Motion to withdraw plea. They accepted that. And then it was a motion to All right. Suppression. Motion to preclude statements made during the course of a plea deal. And so what she's trying to say is that she gives a timeline. She does a really good job with this timeline. And bottom line is, on March 16, 2023, Henry Tennant entered a plea of guilty to second-degree murder with a negotiated range of sentence of 15 years in prison up to life imprisonment. Then nothing happens until February 17, 2026. This honorable court permitted Henry Tennant to withdraw his previously entered plea of guilty. Mr. Tennant's case remains on the trial track in the discovery process. So the memorandum of law in support of suppression is the defendant's statement must be excluded because it was made in connection with plea negotiations and is inadmissible under section 90.410 and rule 3.172. Florida law unequivocally provides that statements made during plea negotiations are inadmissible in any criminal proceeding. The state is saying that these were to further a plea, and so it's different. And she's like, no, the fuck it is. There's nothing being furthered here. Okay, furthered means the court has accepted it, and that'd be talks like afterwards, and that just didn't happen here. She's saying that a plea of guilty later withdrawn and offer to plead guilty and any statement made in connection with such plea or offers. The purpose of this rule is to promote free and open plea negotiations without fear that a defendant's statements will later be used against him at trial. The Florida Supreme Court has repeatedly emphasized, so like to me this is like a no-brainer, but it's because of this timeline. And it's just like, how is it Henry Tennant's fault that y'all just sat there and didn't do anything with it? Okay. And you didn't move forward on this. Okay. Why should he be penalized? He shouldn't. Okay. So whether that expectation was reasonable under the circumstances, and so you have to ask yourself, what did Henry Tennant think he was saying? What was he doing? The record demonstrates that the defendant's statements was given as part of an active plea agreement process. This is all that they talked about. The sworn statement at issue was clearly taken as part of a negotiated plea agreement process occurring before any entry of the plea. At the beginning of the sworn statement, the prosecutor explicitly confirmed that the statement was being taken in connection with the plea agreement scheduled for the next day. Tomorrow, you are going to enter a plea deal in your case. Tomorrow, you will plead guilty to the charge of second-degree murder with a weapon. These are the quotes. The prosecutor then explained the negotiated terms of the plea agreement, including 1, the defendant would plead guilty to second-degree murder. 2, the state would drop additional pending charges. And 3, the defendant would testify truthfully against a co-defendant. Thus, at the very outset of the sworn statement, the parties acknowledged that a plea agreement had already been negotiated and would be entered, but only if Mr. Tennant provided the statement. In order to have this all happen, he has to provide the statement. So the statement was being taken in furtherance of that agreement and anticipation of the plea hearing scheduled for the following day. This is precisely the type of circumstance contemplated by this rule. If the defendant clearly had a subjective expectation that the statement was part of the plea agreement, the first prong of the Robertson test asks whether the defendant subjectively expected to negotiate or finalize a plea agreement when given the statement. Here, the transcript leaves no doubt the defendant believed the statement was part of the plea agreement. Under these circumstances, any reasonable defendant would understand that the statement was being provided in connection with the negotiated plea resolution of the case. Florida courts have repeatedly held that where a defendant provides a statement expecting favorable treatment under a plea agreement, the first prong of Robertson test is satisfied. So then the defendant his expectations that the statement was part of the plea negotiations was objectively reasonable. The second prong of the test is that the defendant's expectation be objectively reasonable, right? So am I making this? Why am I even talking about this, right? Well, because we're making a plea deal. So of course I'm talking about this. But what am I talking about? What am I even saying? What am I admitting to? What do I have to do? Okay, yep. Well, this is a negotiation. Okay. Well, now the second part is the defense expectation that the statement was part of that plea negotiation was objectively reasonable. Fuck yeah, it would be reasonable to think that. Before questioning began, the prosecutor explained the terms of the negotiated plea agreement and confirmed the defendant's understanding of the agreement. After laying out the potential terms of the prosecutor then says, in quotes, and no one has promised you anything other than what potential terms the prosecutor states. And no one has promised you anything other than what we've talked about, 15 to life on that charge, to get you to say what you're going to say here today. How I could not believe this is a quote. This is how it was recorded. And no one has promised you anything other than what we've talked about. 15 to life on that charge to get you to say what you're going to say today. How to further what you talked about the day before, right? You guys, to get you to say this. The only reason he's saying it is because of the deal. He's not saying it because it's true. He's saying it to get the fucking deal. Right? I mean, how that could be possibly interpreted any other way is mind-blowing to me. Now, let's go back over here and see if where's Jacksonville First Coast people. 1 o'clock today. I mean, unless they, here we go. Yes, got it. You guys, this is like hands down. If this gets denied, notify me. If this gets denied and they're able to use these statements, you're going to have Henry testify at trial. Because he's going to have to testify as to why he said anything and everything that he said. If anybody deserves a fundraiser to fund money to be able to get him out on bail so that he can work with his defense attorney, this would be a man that is owed that. He is going to have to say why he said anything and everything that he said. And I think that I would have been arguing that is that my client's going to have to pick a he has the right to remain silent, right? Anything that you say can and will be used against you. Okay? Awesome. But then that's in February. Then you get to these plea negotiations where then the opposite thing is said to you, which is that whatever is said here can't be used against you. And then so we have that understanding, and then whatever then he would have said on the 16th somehow is now not under that. Like, it's like, what? I think Judge Kite, am praying that she sees through this bullshit. Okay? Again, Mr. Tennant was expected to make, and therefore the negotiation was still actively occurring. Courts consistently hold that statements made following such discussions occur within the plea negotiation process. Just because you have a deal the day before that, okay, tomorrow I'm going to say this stuff, to the courts in furtherance to complete this deal. How is that not? They're just trying to use what he said then in court, but that never happened because the courts never accepted the plea deal and they never sentenced him. Um, Finally, at no time during the sworn statement meeting on March 15th, nor during the formal plea colloquy on March 16th, was Mr. Tennant advised that his statements made on March 15th could be used against him if he might later withdraw his plea. So again, this timeline is just really important. When he was first arrested and you're asked, anything that you say can be used against you, okay? And you're sitting there in a meeting or in an interview or in an interrogation from the traffic stop, okay? That's not what we're talking about here. Because we're talking about when he was arrested then a second time while he was in county, and that was in January. And then he was arrested for the traffic thing in August, then he just sat there, okay? Then in January, they arrest him, they rearrest him and charge him with murder, second-degree murder. And that's when they have that big press conference. That's in January. Then he's assigned a public defender, okay? And that's Alan Chipperfield. And then Alan Chipperfield talks to him. And then in February, they begin these plea negotiations. Why do they begin these plea negotiations? Because the state needs Henry Tennant in order to make a case against Mario Saldana and Shanna Gardner. So we need you to say that you were the shooter and they hired you. And Alan Chipperfield just fucking sat here and let his client be in the room. Like, I'm sorry, if I was attorney, my client is not speaking to anybody. Like, fuck out of here. We will talk. I will take it to my client. But why would I ever subject my client to communicate with fucking AGs? Out of your mind. So then here we get to this timeline, which is in February, the plea negotiations start happening at the end of February. And then we get to March 15th, which is, okay, we're going to go forward with this. You're going to say X, Y, and Z to get this deal. Because what do they have on the back burner? They need that statement in writing and to be signed so they can do what? Arrest Mario right then thereafter. And they arrest Mario in March. And then they arrest Shanna Gardner in August. But she's over here arguing and saying that finally at no time during the sworn statement meeting on March 15th, nor during the formal plea colloquy on March 16th, was Mr. Tennant advised that his statements made on March 15th could be used against him if he might later withdraw his plea. And it's like, wait, what? What he said on the 15th to the 16th is from the negotiations. It's part of it. And then whatever he says on the 15th to the 16th is because of the deal. So if I'm taking the deal back and the court said, yep, you can get rid of this deal, then it just needs to be suppressed. No, the state should not be able to use any of this at court against him. Sorry. Oh, here we go. The state's argument is, in Grover v. State, the court determined that two separate sworn statements given after a full plea agreement had been entered were admissible against the defendant. In so ruling that the court gave great weight to the fact that the plea had been executed prior to the statements. Thus, the negotiation was over. And what Julie was arguing is saying, first of all, this negotiation would not be over until Mr. freaking Tennant testifies truthfully to fulfill the damn deal. Okay? because so her argument is that, you guys, there are so many working parts here in this ridiculous fucking slopped up, thrown together bullshit that y'all know is bullshit. And then so she cites, what I love about what Julie does is she puts all the case law on the table. She doesn't hide ones that like aren't favorable. She throws them out there, and then she shows how this case law has nothing to do though with our case, because these are the circumstances of our case. There were no set in stone, all this shit, nothing. So, also she cites that in Wainwright versus State, the court permitted the admissible incriminating statements made over an 11-day period after an agreement had been reached to waive the death penalty. That agreement required the defendant, 1, did not contribute to the death of the victim, 2, cooperate fully, and 3, pass a lie detector test. In determining the statements were admissible, the court gave considerable weight that the defendant in the case had been specifically warned that if he could not complete all 3 requirements, all statements could be used against him. That never happened to Henry Tenen. It was never said to Henry Tenen, if you don't do all of this and you try to back out of this shit, all of this can be used against you. And Julie brings that up, and she gets his lawyer to say, yeah, that never happened. He was never told that any of this could be used against him. And so she gets the lawyer, his old attorney, on the stand admitting to these facts. And then Judge Kite's like, I have to go with the facts that are presented here before me. And basically, off of Alan Chipperfield's testimony alone, I think that Judge Kite's not going to be, she's suppressing this. You're not using this. But I think regardless, I would appeal it if it doesn't go my way. But even more importantly, I think that you need to consider the fact that you're putting Henry Tenen in a situation that he would have to testify, or we're talking about waiving client attorney privilege, because then we're going to have to use Alan Chipperfield to testify to clear all of this shit up at a trial, which I don't think, prove your case. Prove your case and stop trying to railroad people. Henry Tenen is not the shooter or any of the shooters. So according to Julie, she's saying that the facts in this case are different because in those cases, the negotiation was complete. Here, the ongoing negotiation was dependent on Mr. Tenen making certain statements. And what Mr. Tenen said on the stand today was that I wasn't going to testify. Like, I wouldn't be testifying truthfully. And he's like, oh, so you lied back then? And I think that's where Henry Tenen wanted to be like, no, in order to get my plea deal that was shoved down my throat, and you guys are telling me I'm about to die. So yeah, of course. Yep, sure, whatever. What do you want me to say? Mm-hmm. But only if you do this truthfully. They're going to do this via Zoom. Oh, oh, no, just one of the people I think is showing up via Zoom. I just think that this shit needs to clearly end, right? Like, come on. I think that Julie, if she had enough time, okay, there's witnesses that at that point, like, I probably know more about the case than she does, God bless her heart. But those prosecutors knew that Henry Tenen would be testifying not truthfully if he's going to be testifying as a shooter. How it looked how they explain it to Henry is that it's your truck, it's your phones. You know, they used you. We're here. We're going to give you. We want to give you this deal because we know that. We know that. Okay. I understand that you want to give me a deal. Okay, I get that, but you can't say the deal isn't that he's the shooter. He's not the shooter. When he's telling you that he was not the shooter. And earlier, that's why I thought it was really important that why they did that press conference the way that they did it, it was to announce all of those details. You guys understand that those details were announced January of 2023, and Henry Tennant doesn't begin his negotiations until February of 2023, thereby giving him this material about a tire in the middle of the road, everything that they said. Saying that his truck was used in the commission of the crime. It's pretty wild. I just would have been correlating I would have correlated a way more comprehensive timeline to say, Your Honor, the state knew when they were taking this man's statements for this negotiation that he wasn't the shooter. But they didn't care. And in fact, they needed that to be the situation because their other unindicted co-conspirators, they're lying too. So Shanna Gardner is, I think it's really interesting arguments. Something that's different that the Gardner team is going after is they're going to test the authenticity of probable cause here because there's no what are you expecting to find? They said that Shanna Gardner participated. First of all, that she solicited Henry Tennant to commit murder. Okay. So there would be plotting and planning that you're going to be trying to say in your search warrant. Okay. To be able to get into things, you need to be specific about what you think you're going to uncover. What's the crime that you're charging her with, and it's going to reveal this. They don't say any of that. Okay. In fact, for her iPhone, the supporting affidavit was submitted by Detective Jason Lamont, and it was seizing 20 different categories. First of all, when do you think that this? She didn't know Mario until X date. Okay, she didn't know. Then have the possibility to possibly know Henry Tennant or John Biggerstaff or any of these people until knowing then him. So why are we going back and searching back in 15, 16, 17, 18, 19? Why are we going back that far? How are you able to justify going back that far? Because the people that she was plotting and planning with that you're alleging she didn't even know, and you know that. That's number one for me. Okay. Again, if you're trying to go for pattern of life, get it. That's totally different. You want to use 180 days to 365 days. But we're talking about you're specifically saying that this woman plotted and planned with these people, conspired with these people. So it should be specifically to the communications with those people during a time period, right, of potentially ever being able to know them until present day when you're seeking and serving a warrant, right? How can you justify going and getting material that's outside of that scope? I just don't think that you can. Next, so they don't limit this. They say to any and all without restriction. They say, by way of example, it authorized seizure of any data related to user logins and passwords Why the heck are you going my user login and password? How is that going to tell you that reveal that I committed a crime? I think that's bullshit. Any communications accessed, written, sent, or received or deleted, categories boundless in both time and subject matter. No, absolutely not. Again, this is the one that's in 2023. And what are we basing this off of? Not only are they going after her iPhone, the iPhone affidavit sets forth extensive allegations of probable cause against Miss Gardner's co-defendants. There is nothing of her being alleged. Of all the allegations that do concern Miss Gardner, nearly all are described conduct occurring after the murder. So you're looking at her as an accessory after the fact. That's your probable cause if you're providing us with stuff after the murder. So, I mean, what? All the allegations that concern her. The only pre-murder allegation are that Miss Gardner was previously married to the victim and is presently married to Mario. That's it. Association. Can you imagine if you were my roommate? Think about this. We lived together in college. We lived together after college. Because you're my roommate, your phone should be seized in its complete entirety. Why? Because the cops are alleging that you conspired with me to commit premeditated murder for hire. Okay, well, why are you saying that you're going to find crimes of murder in my phone? How are you going to find crimes of murder in my phone? You need to be specific in saying you're looking for conspiracy to commit murder, right? You're looking for communications, plotting, planning. That's how specific you should have to be. The iPhone affidavit contains a section titled Information regarding the function of cellular devices supporting the obtaining of data in its entirety. Because of the functionality of a cell phone, you should be able to obtain my cell phone because of its capabilities. Are you out of your fucking mind? My husband can ejaculate and sperm comes out. You should be able to get his sperm when you arrest him. You should be able to get his sperm. Because he has the capability to produce it. That's my motherfucking argument. Take that one, put it in some case law. I want to see somebody make that argument in open court. Dude, see, this is how, but I would make that argument. You don't get to just, what are you talking about? Just because of the capability. My phone has these capabilities. In a criminal, like, this is how criminals function. Detective Lamont describes the vast quantities of personal information stored on a modern day cell phone and asserts that the entirety of the device is necessary because it may convey communications between parties and identify suspects, co-conspirators, associates, witnesses, and other individuals who may have involvement or knowledge of crimes. That's not how you get fucking search warrants. Wait. What is that being specific to? What's the particularity here? These are general warrants. Fuck these. It get tossed. The reason we're looking at this screen like this is Florida. We're about to start. I don't know what their delay is over here. I mean, is it just me? Or can these people not function? Like, look at this. Look at this shit. The generic rationale untethered to any specific crime any specific allegation against Ms. Gardner or any specific category of evidence was the sole justification under or offered for the seizing of Ms. Gardner's entire phone. And it was accepted by the judge. How? How? The warrant was signed February 22nd, 2023. Well, that's interesting. When did those negotiations start with? See, all of this was all tied together. Anyways, then this iCloud warrant. April 3rd, 2023. That is a whole year after the murder. And you're going for the period of November 1st of 2021 through March 27th of 2023. The supporting affidavit was submitted by Detective Christopher L. Johns. The iCloud warrant's disclosure provisions, paragraphs 1 through 9, demand, without subject matter limitations, the entirety of all emails, all iMessages, all iCloud backups, all Apple and third-party app data, all photos, all videos, all location data, all FaceTime logs. Do you guys understand when they went ahead and first did these warrants for location? Shanna Gardner, her phone, her person, her car, everything's at the house. They do these little geo-fence warrants all across the town. Shanna Gardner's in none of them. So how are you furthering anything when you're like, you have to provide, you shouldn't have to write in the search warrant that nothing came back when we did this and nothing came back when we did that. But now here, we want all of the iCloud data from November 1st, 2021 through March 27th. And it's like, why? What are you putting in your warrant that you think that what's going to be there? Right? They wanted all transaction records, all device identifiers, and all files and other records stored on the iCloud. Just everything. Then, after they put that in, after Apple already gave them all the shit, they then put a separate provision that limited the information to be seized by law enforcement to evidence of violation of premeditated murder. But this was only after Apple had delivered the entirety of the account to police. The iCloud warrant acknowledges that the requested timeframe of 16 months is longer than would be typically requested, justifying the expansion on the ground that this is a contract murder for hire, and the detailed planning, execution, and cover-up. Detectives Johns did not, however, seek a warrant for murder for hire, nor did the issuing court find probable cause for that. So your affidavit isn't matching up with what Ms. Gardner is being charged with. Because she's not being charged with anything. This is April 3rd, 2023. She was not arrested until August of 2023. Who have you arrested? Henry Tennant was second degree, child abuse, conspiracy. They were just writing anything and everything. And I'm telling people right now, like, I just think that this is bullshit, this whole Google shit. Also on April 3rd, 2023, the court issued, they didn't do any of, mind you this, they didn't do any of this shit in the Drake case. They didn't even go into Drake's home. They did not seize any devices at Drake's property. There were cameras on his property. Why don't you look and see what's going on with the cameras? Wouldn't that be a great way to just rule out her physical, like that she's physically where she says she is? And when she leaves with her friend Amber and shit like that. But here with this Google shit, the supporting affidavit was also submitted by Detective Johns. The Google warrant disclosure provisions, paragraph 1 through 24, demanded, without subject matter limitation, the entirety of all Gmail messages, all Google Drive contents, all Google Drive docs, sheets, files, all Google Voice recordings, all Google Photos, all Google Sites files, all Google Plus data, all Hangouts communications, all web browsing history, all search query history, all click history, all analytical data, all geolocations data from every device ever logged into the account, all app downloaded history, all third-party application connections, all deleted data, and all account access records. Like the iCloud warrant, separate provisions limit what may be seized to evidence of the charged offenses. Again, this is only after Google has delivered everything to law enforcement. The Google warrant further authorized seizure of all evidence which tends to show a crime has been committed. Again, guys, how does your Google show you that a crime has been committed? It doesn't. Google doesn't alert you and say, crime here, look over here. What? This has to stop. The Google warrant further authorizes seizure of all evidence which tends to show a crime has been committed. Any crime, not merely the offenses for which probable cause was found. The return was filed July 14, 2023. That is such a long time to have a return. Usually, like when you're giving out these warrants, okay, April 3rd, 2023, you're getting a return here like 14 days. April 3rd, July 14th, 2023. You want to know why? Well, fuck, that's a lot of data. I mean, I just don't. And so on August 17th, 2023, the grand jury returned an indictment charging Miss Gardner with first-degree murder, conspiracy to commit murder, solicitation to commit a capital felony, and child abuse. What the heck are they doing? Black Cat and Jam. Good evening, lovely smart firecracker. Hello to all those in chat. Great catch in the second part of today. Husband's birthday. Woohoo! Shake it. Shake it. Shake it. Fuck yeah. Happy birthday. That's awesome. Little Miss Maid. Oh, Jane, what's good, girl? Shaking it? Good. What are they doing over here? Dude, what is going on? What is Judge Kite running here? Take a look. Coffee Master, I just got that stuff. Perfect, thank you. Is that what it says, Jane? All right, let me see if they're doing tweets. They should be explaining to people what the hell, why this has nothing going on. What are we on here? First Coast News. 13 watching that. Started streaming 26 minutes ago. Maybe I should comment. Be like, what, can you even comment? Okay. First Coast News. They suck. What's going on the site? Oh, shit. Nothing. Well, Alec Murdoch getting a new trial. They don't even have anything posted on Twitter. Like, what are they doing? Are they not allowed to show this live and they just upload it? Is that the problem here? They only get permission to like record it and not live stream it. You guys see what Angela Levy put out yesterday and what that dude said about his guest a year from now? What was that? Like we've always watched live. Like what the heck are they doing? I might just call the courthouse and say, what the, what the, what the, what the. God, you guys, you can't make this up. Can't make this up. Breaking news. Oh, Aiden Carney's motion to dismiss hearing is being moved to another date due to a family emergency for one of my attorneys. I will let you know when that date is as soon as I find out. Thank you for your continued support. Aiden Kearney, no hearing tomorrow because of an emergency with a family emergency with one of his lawyers. Well, praying that everything's okay. Okay. But well, they were already in Boston. You know, Karen, shake it, shake it, shake it. Woo-hoo. You guys, this is bullshit. Good thing I have documents. Okay, so I want to show you. I created a spreadsheet. I took all of what's going on in the Shanna Gardner case. You guys, they weren't testing anything at the lab. Look at what all they did in the lab. This was like, there was no investigation whatsoever. It was, here we go. This is what we know that happened. It was a murder for hire, or just Mario did it himself. Take a look. If someone can just keep an eye on my, as soon as I click off, you guys know it's going to come on. Get real. Um, the other folks. All right, so I created this. At the crime scene, they tested a bunch of stuff, took stuff into evidence. Okay. But here is truly what they just sent to the lab. But just because you take it doesn't mean anything, happens. So they took the 4 shell casings. 2 of them were Underwood, 2 of them were PPUs. Okay. And the way the report was written, it was messed up. So I'm not 100% sure if all of them had the single profile on them, but the shell casings that were there link to Jared Brightigan, the victim. They were like his bullets, his ammunition. It's really bizarre. Then they did known biological samples, and 7 through 13 were techs that worked on the case. Okay. Then there was like 4 or 5 different swabs of this. There's a stain on the tire. So that was item 14. And they did like 4 or 5 swabs. They took a swab taken from the valve stem of that tire that was in the middle of the road. And they took 2 swabs taken from the outer rim of the tire, and that came back as multiple profiles for DNA. And again, swab taken from the inner rim of the tire. Again, this is the one that's in the middle of the road. Okay. But it just came back as multiple profiles. And it also, anything that, when they were claiming that they had Henry Tennant's DNA at the crime scene, that at the time that was said to him, that's absolutely not true. Why? Because I have all the dates. Now, after that's all they put in, and look at what they do here. The next thing that gets tested is when the victim has the autopsy, they do a victim DNA blood card. Then they take known elimination DNA samples. So during their interviews, Mario gives up his DNA, and so does Shanna Gardner. No search warrant needed, no nothing. Kirsten Brightigan, wife of Jared Brightigan, and those are those numbers. Oh wait, we're back. Okay. We're back. Shanna's lost some weight. Okay, dude, I'm so stoked for this shit.
All right, so we have a few motions, and I want to know kind of where the parties want to start.
Some discussions with the defense counsel, Mr. Carodi, regarding the defense motion to exclude testimony of minor child BB.
Was that adopted by Fernandez too?
Yes.
It was, Your Honor. I've had discussions with Mr. Dreiser as well. The state's position is at this time the motion is not ripe to be heard. It's not a constitutional suppression motion. It's a motion to exclude testimony. The state has told Mr. Crody and Mr. Dreiser we would like the opportunity to sit down with the minor child BB, speak with her ourselves, determine if we believe we will call her certainly as a witness at trial or not. If we do make the decision to call her as a witness at trial, I think both sides would agree that a competency hearing would be at that time.
Mr.
The court can rule on this motion without conducting that analysis and without hearing from BB themselves.
Do you agree with that?
Partially, Judge. I do think the court can rule based on section 403 and 604, 403 and 604 as articulated in the motion regarding the minimal probative value of her testimony and using the evidence that we attached, which is the forensic interview that was done with her, I believe, 2 days after the incident. So there are two grounds. Your Honor, the first one we don't believe involves BB. That is your consideration of the probative value of her testimony and whether or not it's outweighed by unfair prejudice. That argument is simply that there's no dispute that BB was in the car at the time that Mr. Bridigan was murdered. There's no dispute that she was 2 years old at the time. There's no dispute that she was in a rear-facing car seat in the back passenger side of the vehicle. There's a picture attached to our motion as well that shows her car seat in the position that was an ET photo. There are several scene witnesses that took BB out of the vehicle, and BB's the one thing that we believe BB would add based on her forensic interview that's before the court is that she heard booms. There is surveillance footage that captures the gunshots in this case. And there is no dispute that Mr. Bridigan was shot. And so our position is that on a 403 and 604 ground that she's two, she was in a rear-facing car seat. There's a forensic interview of her where the only thing that's probative at all is that she heard booms, and daddy got sick, I think is what she's saying. And Your Honor, there's simply no dispute that she was present in the rear-facing car seat. And so there's minimal value in parading a very young child into a trial of this magnitude. And so we would ask that the court, without further information, without further evaluating the child's competency, just make the call. Now, if the court's unwilling to do that, we do have competency concerns. She's a very young child, but we agree with the state that the first step in that, the state has indicated to us that they are not sure that they're going to call her. And so if they do not intend to call her, then there's no purpose in going forward with a court-appointed expert to evaluate the child's competency. And there's no point in us trying to depose the 6-year-old child now.
Yeah, keep her out of it.
So just a couple of things. I understand what the defense is proposing to me. However, I look back at the indictment, there's count 4 where BB is named. And so exclusion of potential quote unquote victim testimony, I think to just automatically rule, I'm going to wait, I think, to see if it's offered, right? So just across the board, exclusion of witness testimony is a harsh remedy / sanction. If I needed to do the analysis, I'll do it if the state says that they're going to offer it. So I'll just hold this one. Okay. I think that's.
I would ask that the court set a deadline for the state to make the call as to whether they are going to call her as a witness. A very reasonable deadline, sometime in June, give them more than a month. But I think that we need trials coming up.
No, I agree. We're running out of runway. So when does the state believe that you're going to make the call?
I've told Mr. Curry that I intended to speak with her in June. We've been heavy in our depot's schedule in the month of May and obviously preparing for these.
You've had fucking 4 years.
Mrs. Bridigan, BB's mother, they are out of town, so I have not had the chance to coordinate with her. But if the court wants to set a deadline at the end of June, that's fine with the state.
No, sooner than that. June
Good.
15th.
You have the following week. I'll be out the week of the 8th. 22nd.
Get the fuck out of here.
So what I'm hearing, so let's say hypothetically, the state does intend to call her.
There's no time.
Someone wants to do a forensic evaluation.
No, if they don't intend to call her.
No, I said if.
If I think the law demands it at this age, that there has to be an independent forensic evaluation ordered by the court regarding her competency. She was 2 years old at the time. Competency is judged at the age at the time of trial, which is 6. But the law is pretty clear that 6-year-olds have to be evaluated for competency.
Your Honor, I believe the court makes that determination.
In a hearing. What are you citing?
Stand trial, it's competency to testify, which is the court would inquiry with the child.
Dude, think if this was a divorce case. Or get out of here.
Understand the difference between right and wrong, a truth and a lie, can present testimony in a coherent narrative manner.
I don't want to push. I don't want to push, but I feel like I have to, okay? It's May 13th. If I wait to June 22nd,
Yeah.
y'all have not taken a deposition, correct, of BB?
They have not known.
You're correct.
Right, and so when would you all, so let's say I wait to June 22nd, when would you all be able to accomplish that? And then this court have a hearing?
June 18th, then, Your Honor. That gives me the, I'll return investigations a week prior, and I'll give you
I
Do it,
understand.
do it before. What?
the 18th. I'll have an answer from defense counsel as to whether we believe.
What?
June 18th?
That's that.
Sorry, but I just don't know, I mean, this has a domino effect on everyone's schedule, and then there'd just be no way to get it accomplished. So June 18th will be the deadline. Thanks.
This is unbelievable.
And Judge, the case that I was citing for the independent forensic evaluation is
Yes.
Lloyd versus State. That's Florida Supreme Court, 524 Southern 2nd, 396. And in that case, I don't know that it's required, but the defendant did motion. The court granted it.
Wait. 520, is Lloyd,
Lloyd versus State,
was it recently decided?
1988,
1988, okay. I'm thinking another one. 524 Southern 2nd,
396.
396. Thank you. I'll look at it, but if I'm going to hold it, then I'll read it.
Yes, Judge.
Okay. So this was for the forensic evaluation?
That, and we're motioning for that, I guess, as opposed to saying that it's absolutely required under Florida law.
It is. It's required for Ohio.
Okay. Which one do you want to take up next?
Judge, if we could call up the motion to suppress the wiretap evidence?
Yes.
Okay. 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 Thank you.
Here we go.
Okay, I'm ready.
Yes, Judge, and as a starting point, I don't think there is any dispute on the law between the state and the defense here. And as I heard this court state this morning in Mr. Tennant's case, oftentimes motions turn on the facts. And so I'm going to focus more on the facts and the law. I believe the court knows that essentially it's supposed to give deference to the magistrate or the judge in this case that signed the warrant. But we do ask the court to conduct the appropriate review of the wiretap warrants that were provided to the court. I've also provided a disc to the clerk, Your Honor, with the same documents that were provided to the court. Your Honor, the wiretap evidence should be suppressed because the intercept orders were not supported by particularized probable cause. The state's presentation was voluminous. It's a very long document, but volume does not equal probable cause. The application and the affidavit repeatedly grouped Ms. Gardner together with other target subjects, but the facts actually alleged against each person are materially different. And this court must evaluate the probable cause for Ms. Gardner separate and distinct from the other targets. The affidavit contained direct evidence tying Mr. Tennant to the murder scene, the suspect truck, and the tire. It articulated evidence tying Mr. Fernandez to Tennant, Ordway, and Biggerstaff and the rental property. And it articulated communication or movements between those individuals, those four individuals, not Ms. Gardner. The allegations in the affidavit made against Ms. Gardner were largely motive, family court history, post-defense media reaction, and her marriage to Mr. Fernandez. That is not enough, Your Honor, and it should not have been enough for the reviewing court if the reviewing court had actually looked at the affidavit and analyzed it as they were required to do under the law. Because what we're talking about here are real-time interceptions of private communications of a United States citizen. The January application expressly identified the 5 target subjects. Those were Tennant, Ordway, Biggerstaff, Fernandez, and Ms. Gardner, I'm sorry, Tenon was in jail at that time, but in collective terms, held that they had motive and opportunity, confirmed relationships, communication patterns, and evidence of the conspiracy. So he used generalized terms and then sought to intercept the phones of Fernandez, Gardner, Biggerstaff, and Ordway after law enforcement was to publicize Tenon's arrest in order to trigger communications among the targets. So that's the framework that the police and the state have orchestrated with the hopes that they would get a warrant to record all of these individuals' phone calls. But here's the problem. Biggerstaff was described as Fernandez's longtime associate, having frequent contact with him before, during, and after the homicide, and having lied about a potentially relevant firearm that may have been used in the murder. Ordway was described as Tenon's roommate who had been Fernandez's tenant, and someone believed, I'm talking about Ordway, someone believed to have had a role based on witness statements and phone records. Ms. Gardner, however, was described simply as Bridegan's ex-wife, Fernandez's spouse, and that she lived in her house where the children were dropped off that night. The affidavit sets out evidence that the homicide was a planned ambush, that Tenon's truck and tire were connected to the scene, that Fernandez was the single link between Tenon and Bridegan. It then asserts that Fernandez enlisted Tenon, Ordway, and Biggerstaff to assist in the murder. And the only link is that Miss Gardner, quote, provided monetary compensation to Fernandez, which he then used to compensate Tenon.
It's not true.
Now, besides the fact that monetary compensation to Fernandez is simply false, and this court knows that from prior evidentiary hearings, that there's no evidence that Gardner provided any monetary compensation to Fernandez, which he then used to compensate Tenon. But the factual basis for the affidavit's leap to connect Ms. Gardner is thin. It's simply motive. It's not a communication. It's not any direction. There's no evidence of any actual payment by Ms. Gardner or any specific transfer of money or funds. There's no surveillance that observed anything involving Ms. Gardner. There's no cell site location records implicating her, and there's zero statements by anyone connecting her to the alleged murder for hire arrangement. The state's strongest facts against Ms. Gardner were simply motive facts.
Those aren't facts.
The
Speculate.
assertions, the motive, is not the same as probable cause. Because even the state's case law that I believe they're going to give the court, you have to have facts. You have to articulate specific facts that connect someone to a crime. And they simply didn't do it. Many people have contentious divorces. Many parents have custody disputes. Many people consult lawyers, public relations professionals, friends, and family after being publicly associated with a homicide investigation. And the United States Constitution in Chapter 934, they require more before the state can listen to private communications in real time. There's nothing that particularizes probable cause against Ms. Gardner. And there's nothing that shows she knew about the tire, the truck, the firearm, the plan, or any
Nothing.
payment to Mr. Tenon.
Nothing.
The application's trigger action section further exposes the weakness in the probable cause showing that the reviewing court should have picked up on if they had not abandoned their role. The state did not claim that Ms. Gardner had made incriminating calls before with anyone, or that there was a real probability that she would make them if this trigger thing happened. So it was not a, hey, we know she discusses the murder on the phone with other people. Instead, it planned to create a media event and then listen to her reaction.
Yeah.
And so it relies on leaking to this leak to the media that there had been a break or an update, and then announcing Tennant's arrest. And that may have been an investigative tactic, but it cannot support probable cause retroactively. It had to exist before the interception began. And a plan to provoke conversations about a highly publicized murder investigation does not prove that Miss Gardner was likely, or that they had probable cause to establish that she was criminally involved. There's also issues with the February application, Your Honor. That's an application where the state obtained a wiretap for Miss Gardner's sister's phone, SH, believing that based on an intercepted phone call, Miss Gardner would seek to use her sister's phone when her sister was visiting her. Your Honor, there's not probable cause to believe that any conversations using the sister phone would actually have supported, would actually have occurred that would have discussed the murder, that there was probable cause at that point that Miss Gardner, again, was involved. In the February application, they rely on actual intercepted statements. You'll see that. But if you actually read or look at how they describe Miss Gardner's calls with Miss Jensen, they're discussing media coverage, public relations advice, alternative theories, some concerns that Mr. Tennant might implicate her, and a concern that law enforcement may interpret some seed money that Mr. Fernandez gave to Mr. Tennant as a payment. Those are not admissions. Those are consistent with a person who knows she's a suspect, is receiving legal advice, and is worried about media pressure. There's simply no connection, no nexus that is necessary between the crime here and recording Miss Gardner's phone calls, either in the January application or the February application. The warrants rested on guilt by association and investigative hope. And Your Honor, that is not simply enough to wiretap someone's phone. I know we don't like to say that the standard of probable cause is different depending on what type of warrant the state is seeking. But there is a whole section in the Florida statutes dedicated to wiretapping for the very reason that it requires heightened scrutiny. And the reviewing court did not sufficiently read this affidavit and the application with respect to Ms. Gardner and simply rubber stamped it. There was not probable cause here, and the wiretaps were unlawful, Your Honor. And for that reason, this court should suppress the wiretap evidence of Ms. Gardner's phone and her sister's phone.
Thank you. Hear from the state.
Yes, Your Honor. I provided a case to Mr. Carudi, which I'll provide to the court as well. United States versus Ventresca, VENTRESCA, 380 U.S. 102. It's a United States Supreme Court case from 1965. And what it discusses is the deference given to a magistrate's determination on a search warrant. And the court goes through a historical overview of the purpose behind a search warrant for the Fourth Amendment purposes, and that the case law and the review by those looking at a magistrate's determination is given great deference because the courts historically have accorded great preference to police action taken under warrant, which is subject to judicial review, rather than search and seizures without one. They discuss that probable cause is less evidence than would justify condemnation. So while Mr. Carudi argues the evidence, in his mind, probable cause is a low bar. In his mind, it may not rise to the level of a higher standard of proof, but certainly the courts have well established that probable cause is a flexible It is a rational and common sense approach to looking at evidence. It is merely reasonable grounds that evidence of a particular crime will be found in a particular place. In this case, the court writes that the recognition that the Fourth Amendment's commands, like all constitutional requirements, are practical and not abstract. That's at page 746. Affidavits tested and interpreted by magistrates and courts must be done in a common sense and realistic fashion. These affidavits and warrants are drafted by non-lawyers in the midst and haste of a criminal investigation. Technical requirements of elaborate specificity, once exacted under common law pleadings, have no place in this arena. And they discourage the court from taking a grudging or negative attitude towards warrants, because that would discourage police officers from submitting them and having that judicial review. The court writes that the resolution of doubtful or marginal cases should be determined by the preference to be accorded to warrants. I say this to the court to say, in no way do I believe that this is a questionable or marginal determination before the court. I believe that the affiant, in this case, outlined with specificity and at length the bulk of the evidence in relation to a conspiracy between multiple individuals and to Ms. Gardner's participant as a principal to the murder of Jared Brightigan. The cases cited by Mr. Carodi in his motion generally support the fact that courts are begrudging to suppress or exclude evidence where a magistrate has reviewed it and where there has been specific and articulable facts outlined by the affiant. The test, he cited Cherney versus State in his motion, 348 Southern 2nd, 395. That is a third DCA case. Court in there, and he cited it for the proposition that probable cause cannot be based on mere suspicion. That the court, in so holding, goes further and says that the test for whether an affidavit establishes probable cause is not whether the evidence is admissible or sufficient to prove guilt at trial, but whether that information would lead a person of prudence and caution to believe an offense has been committed. And that test depends on the probabilities determined by factual and practical considerations everyday life on which reasonably prudent, cautious persons, not legal technicians, act. In the case he cited, the court found that there was sufficient facts outlined in the affidavit that reasonable inferences could be made from those facts, and that an inference is the essence of probable cause. What we're talking about here is a perfectly acceptable way to prove a case beyond a reasonable doubt or by probable cause or otherwise, which is the law recognizes circumstantial evidence as well as direct evidence. The affidavit is replete with both as it relates to Ms. Gardner. There is a discussion of direct evidence that would suffice for probable cause in her involvement. She is one of the co-owners. She was the one who applied for a limited liability corporation license for First Choice Home Rentals, which is the account on which the payments to Mr. Tenen were drawn. There is evidence in here that she financially contributed initially to First Choice Home Rentals through payments from her trust fund, the Shanna Gardner Irrevocable Trust Fund. So there is a nexus between her finances and the payments that ended up in the hands of Henry Tenen. There is evidence in here from direct statements from Ms. Gardner herself to members of the deceased victim's family that she was, and I'm paraphrasing because I don't have it the page in front of me, but that she was looking for someone to take care of him, to get rid of him. She told a friend on page 7 of the affidavit, she advised a friend that she and Mr. Fernandez had a discussion, that Mr. Fernandez told her he could take care of him and no one would ever know, referring to the deceased victim. That Mr. Fernandez told her, and she's telling this to a friend directly, that he could, quote, get 4 guys, break into Brightigan's residence in the middle of the night and take care of him. So there is direct evidence from her own statements to individuals that are outlined in this affidavit that she had the conscious intent voiced on her desire or hope to take him out, get rid of him, take care of him, hire a hitman, etc., and that she had had those conversations as disclosed to a friend with Mr. Fernandez. And Mr. Fernandez, throughout this affidavit, has direct connections to Henry Tenen, with more than enough evidence to suggest and to prove that he was the shooter in this case. video evidence, Google location evidence, cell site location evidence, DNA, his possession of the vehicle. Court looked at evidence as outlined in the affidavit of her phone discussions or her phone calls during significant times in the investigation with significant members of this conspiracy. Specifically, when Mr. Fernandez was asked to come give his interview to the Jacksonville Beach Police Department on February 28th of 2022. It was scheduled for the next day, March 1st, 2022. He deleted over 5,400 items from his Google account. He went to the interview. Ms. Gardner went to the interview. It outlines their statements to police, which outline their dislike for the victim. Mr. Fernandez's comments to police that the kids would, quote, be better off without him in the picture, that they were fighting for majority custody, that he and Mr. Bradigan had some sort of confrontations, altercations, or disagreements in the past about childcare issues and drop-offs. And then we see in the affidavit outlined at the time known to the affiant that she is calling Mr. Fernandez while in between the time that he had his interview, their children are scheduled, or rather his stepchildren, her children are scheduled for a CPT interview regarding the whereabouts of all parties and the deceased victim, the night of the homicide, that she is repeatedly speaking to Mr. Fernandez as he takes what Your Honor has heard in testimony before in other hearings, but is outlined here, an unplanned spontaneous trip up the coast. There's evidence that Ms. Gardner had phone contact with Mr. Fernandez and with her criminal defense attorney and her public relations firm on August 18th of 2022 when Mr. Tenen was arrested on unrelated charges, unrelated to the homicide. So there is direct evidence of her communication with co-conspirators. There is evidence of her having direct control and or access to funds that were used to pay Henry Tenen. Just because there are innocent explanations for individual pieces of evidence, the law says that the court is to look at probable cause under a totality of circumstances. Just because you remove one fact and can give an innocent explanation to it does not mean that that innocent explanation should or can or shall be accepted. The court can still consider other purposes for that evidence and consider it in the totality. And in fact, the courts caution against doing that. They want the magistrate to look at this in a totality, to look at it with a common sense viewpoint, to look at it at what is known to the affiant at the time and what the affiant's reasonable assertions and conclusions from objective evidence can be relied upon. Detective Johns in this affidavit did not merely say Ms. Gardner has significant contact with her co-conspirators, she contributed financially, she has a motive, case closed. He gave his opinion and he also gave the magistrate the objective data and facts outlined at length. The magistrate was free to accept or reject his assertions based on his training and experience and the knowledge that he received from other agents and other officers in this case, as well as statements he received from witnesses in this case. The Crody's cases he cite, for the most part, the court has upheld denial of defendant's motions to suppress. Further, in the cases he cited in his motion, discuss the exception or the Leon exception for good faith. I know and I understand that the defense is limited in what they can argue to exclude the entirety of the wiretap because of this exception. And if a magistrate issues a valid search warrant that appears to have probable cause on its face, the Supreme Court and progeny of Leon has said an officer, the point of suppression is to deter bad police conduct, not bad magistrate conduct, bad police conduct. So for Your Honor to grant the relief Mr. Corrodi is asking for, you would have to find that this 51-page application and 18-page order that outlines these direct and circumstantial pieces of evidence that draws upon reasonable inferences the affiant made from objective evidence that he provides to the magistrate is so devoid of probable cause that any officer reviewing a validly signed warrant by Judge Meredith Carbula with the 4th District or 4th Circuit here would be unreasonable in doing so, and that's just not the case here. And the defense has failed to meet its burden in showing that to the court. And I just will further cite that in all of these cases that he has cited in his motion involving guilt by association, those are very distinct and discrete on their facts. Those are talking about cases where a car is pulled over and a search is done of the vehicle absent a warrant, or a search warrant of a house where a husband or a wife or an individual is merely present at the time a search is conducted for something tangible like narcotics. And they're trying to infer that because so-and-so is in the vehicle with so-and-so who has narcotics, that therefore we're going to search them and we're going to arrest them for guilt by association on these joint constructive possession issues. This is a very specific case, and the probable cause and factual determinations in this affidavit are very fact specific to a conspiracy, to a long-term plan for a murder for hire, to a cover-up of a homicide, to continued conversations between the co-conspirators. And based on what is outlined in here, the judge was extremely reasonable in finding probable cause, and the officers were even more reasonable for relying upon that in executing the search warrant and intercepting those wiretap communications. So we're asking that the court follow the case law, follow the United States Supreme Court in Ventresca and Leon and its progeny, and deny the defense motion.
Okay. Mr. Purdy, I'll give you the last word.
Yeah, just briefly. So I would ask the court to read the application, the affidavit. I do have some disagreement with Ms. Stifler's recitation of what was included in there, but the court has the document and is limited to 4 corners. The deference that this is a non-lawyer document, Your Honor, I think is not the case here. I'm pretty confident that either the state attorney wrote this or at least edited it before it went forward to the court. So this is not the type of affidavit that deserves deference that law enforcement's writing in the middle of the night. This is obviously a document that had legal work performed on it. And then the only other thing I want to point out is that the whole purpose of a trust, as any lawyer knows, Your Honor, means that you can't control the money. So a judge should have known the fact that Miss Gardner was the beneficiary of a trust means that she doesn't control the trust money. I mean, that is 101 legal. And so
you're arguing that to say what? That the magistrate was.
I mean, the state has tried over and over again to connect Miss Gardner to money, but all they say is that there was the Shanna Gardner trust. Well, it's in the document. Mr. Fernandez was the trustee. Miss Gardner was the beneficiary. A trust means that the trustee controls the money,
Right.
for the benefit of the beneficiary. But the beneficiary can't force a trustee to do anything unless you go to court and you sue someone for a fiduciary duty violation. But,
Okay, so you're arguing that fact to say that when reviewing.
No.
when a judge is reviewing this, a judge should be like, well, what does it matter that there's a trust that she benefits from? That's not her financially. Ms. Gardner cannot financially compensate anyone through her trust. She, as a beneficiary, she has no control over the trust. And that's the point, that there's no financial connection. That Ms. Gardner was on an account that was used to write checks to Henry Tenen that were signed by Mr. Fernandez.
So you're saying a judge should have known that, so that fact should fall away. That couldn't lead to probable cause within the 4 corners. Is that what you're saying?
There's like a bunch.
That seems to be, as the state goes through here and makes arguments, again, I agree the case law is the reviewing judge deserves deference. But I heard the state talk about that was one of the things that a judge could have would have seen and would have agreed that it clearly established probable cause. It shouldn't. Just like the fact that Ms. Gardner had communications with her husband.
Okay.
Thank you, Your Honor.
Thank you.
I'm confused as why the state's opposition is not filed.
Good afternoon, Your Honor.
Good
Kristen
afternoon.
Nelson. would like to take up Ms. Gardner's remaining motion to suppress, which relates to 3 warrants, one for her iCloud account, her Google account, and her iPhone.
She just put in her motion to appear yesterday. She works for Jose Baez.
I'm going to focus primarily on the iCloud account since all 3 warrants have similar problems. I'm happy to answer any questions about the other 2.
Okay.
Your Honor, what we have here is that the state sought and was granted 3 separate warrants that essentially gave law enforcement unfettered access to Ms. Gardner's life. Every email, every photograph, every internet search, and every deleted file. And then law enforcement was allowed to rummage through those files with unfettered access to determine what they thought was relevant.
Or what it means.
To paraphrase Justice Brandeis, the progress of science does not erode the Fourth Amendment protections. And so what we are asking this court to do is to examine these warrants and to uphold what the Florida Constitution and the federal Constitution require. And that is suppression of this evidence. Mr. Carodi has already talked to the court at length about probable cause, but we're again talking about probable cause here. I won't repeat all of the same arguments Mr. Carodi made. We would incorporate them by reference. However, there are some that are particularly pertinent here. The first is, when we're looking at warrants, as this court knows, there are 2 requirements under probable cause. The first is the commission element, and the second is the nexus element. And so I'm going to take them one at a time. So when we're talking about the commission element, meaning, is there probable cause to believe that Shanna Gardner committed the exact crime for which the magistrate found probable cause? So if we're looking at the iCloud warrant, which we submitted to the court, and I'm happy to provide additional copies if helpful, the commission element there is only premeditated murder. That is the only crime for which we are talking about probable cause, not conspiracy, not child abuse, not murder for hire. And that's important because the facts are slightly different. So what we see here, Your Honor, is that we do not have evidence, allegations of Ms. Gardner's involvement at all pre Mr. Breidengen's death. There's nothing in the warrant to suggest that Ms. Gardner was involved whatsoever pre-death. Not only that, the evidence that is cited regarding Ms. Gardner's involvement is more along the lines of conspiracy. But there wasn't a finding of probable cause for conspiracy. So that cannot provide the basis for a valid search warrant here. When we strip away all of the, I'll say, conspiracy-style allegations about relationships and communications with co-conspirators and things of that nature, what we are left with is very similar to an argument that Mr. Carodi made earlier, and that is that the affidavit focuses on Ms. Gardner's intimate relationships. Mr. Breidingen was her ex-husband, and Mr. Fernandez at the time was her current husband. But Your Honor, that's nothing more than a hunch dressed up in a marriage certificate. And the Supreme Court has been very clear, a hunch is still a hunch, and that is insufficient for a finding of probable cause. I would direct the court, and we cited this in our motion regarding intimate relationships and casual associations being insufficient for probable cause, to US v. DeRee, DE space RI, that's at 332 US 581. Unless the court has questions regarding that argument, I'll move on to nexus.
You can.
Thank you, Your Honor. When we talk about nexus, the reason that this is important is because we're talking about warrants that, under the affiant's own admission at a previous hearing, give them massive amounts of information, very intimate information. Detective John said that in Ms. Gardner's bond hearing, and he was right. And so it's not, the Constitution does not allow law enforcement to get all of this data that far exceeds anything related to a crime unless they can show that that specific place to be searched has a connection to the very crime for which they claim that there's probable cause. So what does that mean here? We're talking about the iCloud account and premeditated murder. So what is the relationship between the two? And when we look at the affidavit, there is no substantial evidence that a search of Ms. Gardner's phone ending in 4571 or the iCloud account associated with that phone number would produce evidence of premeditated murder. And that phone number is important, Your Honor, and I'll circle back to that in a moment. But the reason that we see that there is no nexus here is because this affidavit, as lengthy as it is, it doesn't even say that Ms. Gardner had an iCloud account. At base, that should mean that there is no nexus and therefore no probable cause and that this warrant can't stand. But even setting that aside for a moment, the only allegation regarding Ms. Gardner and an iCloud account where the police actually say, we know that Ms. Gardner has an Apple product, is about an iWatch, or an Apple Watch, excuse me, Your Honor. And in fact, that Apple Watch isn't even associated with the phone number for which they requested this warrant, the number ending in 4571. And there are no further allegations that connect Ms. Gardner's use of any Apple products to any other allegations that could be connected to a premeditated murder. And we cite cases regarding this in our papers, Your Honor, but just to remind the court, general propositions and allegations based on training and experience cannot bridge the gap between lacking factual allegations and a finding of probable cause. As Ms. Stifler said earlier, the only thing that they can do is provide context for facts that are actually alleged. We don't have those facts here in order to bridge that gap. The case I would cite for that, Your Honor, is US v. Martin, 297 F. 3rd, 1308. That's the 11th Circuit, 2002. The second requirement, Your Honor, relates to particularity. So we believe that these warrants fail to state probable cause. That means that they should be suppressed. But even if the court finds that there is probable cause, they still fail particularity, which is an independent basis for the court to suppress all three warrants. First, I would start with the date restriction issues. These warrants are slightly different in the scope that they seek. However, I do think that United States versus McCall, MCCALL, it's an 11th Circuit case, 84 F. 4th, 1317 from 2023 is important for this court to take a look at. And the reason is we have a very similar warrant in McCall. Where what we have there and what we have here is a two-step warrant, where the police go to the court, just as they did here, and they seek the entirety of somebody's account, which is exactly what happened here. And the judge signed off on it. And then there's a second step in the warrant, just as there is here, that says, now we're going to comb through this information and we decide what's relevant. In McCall, the 11th Circuit said, well, actually the district court and the 11th Circuit agreed that that was overbroad. That was too much. They assumed, without deciding, that it also lacked probable cause for the very same reason, because it was so broad, there's no way that all of those categories of information could be supported by probable cause. Where I disagree with the 11th Circuit is that they found a good faith exception. I think we're standing in a different posture, especially a couple years after McCall, and there are several Florida cases that I think eviscerate the good faith exception here. But that's important because the 11th Circuit was very clear, and other circuits have been clear as well, that under the Fourth Amendment, when you have a warrant without any date restrictions, that alone warrants suppression. That's what we have here. And the warrants that do have date restrictions, those date restrictions are not tethered to anything meaningful, meaning they're arbitrary. They're not supported by probable cause. They are not particularized to the facts in these affidavits.
Unbelievable.
I would also point the court to United States versus Blake on this same point. It's in another 11th Circuit case from 2017, where the 11th Circuit specifically pointed out that when we are talking about these cloud-based accounts, which is what we're discussing here, law enforcement has the ability to target, to limit, both by date and subject matter. That is oftentimes an argument that we hear in these cases well, we have to take everything because that's just how it comes. And the 11th Circuit said that's not true. They said it in 2017 and they said it again in McCall. And just as it was true then, it is true here today. Law enforcement has the ability to narrow these searches so they are not collecting every piece of somebody's digital life and then allowed to sort through it. That's what we're asking this court to do here. Regarding subject matter restrictions, it's a similar argument, Your Honor. I would point the court to State v. Demons, D-E-M-O-N-S, which is a Broward County case. I believe that Ms. Stifler provided the court with all of the applicable filings. We cited it in our papers. That case is incredibly similar. And the reason that I pointed out specifically to the court is because there were many online accounts in Demons. And the judge specifically found that, number one, law enforcement had the ability to do this limit that we're talking about in step one. So before they get everything from Apple or Google, they could have narrowed, but they didn't. And then in addition, the failure to limit by relevant times or descriptive terms makes these warrants overbroad, just as it did in Demons. So it's a two-step problem. It could have been done in step one, and then failure to do it in step two with any sort of meaningful guardrails, which is what we have here as well, also is a problem under particularity. The final case that I would point the court to, and I'm happy to hand up a copy because I understand Ms. Stifler had some difficulty finding it, is In Re's search warrant application received March 13th, 2023. And this is a bit unusual, Your Honor, but this is a magistrate judge from Miami-Dade County who received one of these two-step warrants, again for a cloud-based account, just like we have in this case. And that magistrate judge denied it and decided to write an opinion on this and publish it because he said, to paraphrase, "We see this problem too much. This violates both the Florida and federal constitution. And so I am issuing this opinion as guidance to those who come to the court and seek a search warrant." We have the same issues here, Your Honor. So unless the court has further questions, I'm happy to.
You have a copy of that?
Yes, I do, Your Honor.
Okay, can I have it?
Yes. Fuck. Fuck, she is good, guys. Holy shit, she just came in for the purpose of fucking handling this right here. She fucking smoke show. Take that, Stifler, you fucking dumb bitch.
All right, Ms. Stifler.
Yeah. The state rely on arguments I made previously in regards to the wiretap, incorporate those into arguments regarding the probable cause as to the affidavits in these search warrants. I will also note for the court, these search warrants are not only focused around the idea that evidence of the homicide itself will be found in these devices. And just for reference, the ICloud does reference the statute numbers for first degree premeditated murder and child abuse. The search warrant does reference the statutes for first degree premeditated murder and child abuse. And the affidavit and search warrant for the iPhone does reference statutes for murder, conspiracy to commit murder, accessory after the fact, and child abuse. Although there is the charges as outlined are under investigation and the charges eventually charged are not relevant to the court's determination of probable cause. By its essence, a premeditated murder involves discussions prior to the homicide, a conscious intent to effectuate the homicide, and therefore would encompass a larger
Not all.
range of time period for a probable cause search, regardless of what type of evidence, inherently in its nature, particularly when we've outlined there are multiple individuals involved in the planning of the homicide. There's no statute for murder for hire. So that should not be a factor for the court that there was some failure of articulation of probable cause or finding by the magistrate for a murder for hire. That is not a Florida statute. It's sufficiently enveloped in the premeditated murder statute.
But that's not what you were alleging. They're moving the goalposts.
As stated in the iPhone. I am going to talk about the particularity requirements for digital evidence. I do have a witness to take testimony before the court at the end of Ms. Nelson's motion. She brought up a Franks violation that the affiant did not include paragraph, I guess rather a Johnson, it's an mention that the affiant did not include a paragraph in any of these warrants or affidavits stating that Google and Apple have the ability to what I'm called selectively characterize evidence either by subject matter or time frame.
Did you let counsel know that you had a witness? I wouldn't have.
Yes, I let.
Okay. And that's how y'all wanted to proceed? I didn't want,
I can either argue first or take testimony from the witness first.
what do y'all prefer?
We'll take testimony. He's a CFIU detective. The state's not offering him as an opinion witness in any way. He's here merely to give context and define some of the terms.
Object.
And discuss Google and Apple policy in general as it relates to the Frank's allegation of selective categorization.
Okay, is he already here?
Yes, ma'am. Detective J.S. Padilla.
They used him.
So we've been going for about an hour. I'll take its testimony and then I'll take like a 5-minute break, okay?
Speak up.
Good afternoon.
Let's see how she crosses him.
Great. You may proceed.
Good afternoon, Detective. Could you please state your name for the record?
Detective James Padilla, Padilla.
Hold on just a moment. We were testing. You can get the body mic.
Give her a mic.
We're trying something new. You can, we turn that microphone off, if you'll push that back.
Oh, shit. What are they doing? You guys,
Where do you work?
The Jacksonville Sheriff's Office.
And what is your role with the Jacksonville Sheriff's Office?
I'm a digital forensic examiner in the computer investigations unit.
And Detective Padilla, are you also a member of the United States Secret Service cross-sworn agent?
Yeah, I'm a task force officer assigned to the Secret Service.
And briefly before we begin, although
holy shit, you guys. This is who they could have went to get into Kaylee's phone. If you go to the Secret Service, they can break into any Apple. Oh my God. Oh my God. Okay. This is really, really important. What he's about to say, I always compare it to other cases that we work. This is really important what he's about to say about Apple phones.
I'm not offering you as an expert, would you mind giving the court a brief outline of your background in terms of your education and training and experience as it relates to computer and device forensics?
Yes, I have a master's in science for digital forensics out of the University of Central Florida. I have certifications in both mobile and computer forensics from the International Association of Computer Investigative Specialists, or IASIS for short. I have certifications from Cellebrite in both their products and some of their Cellebrite mobile forensics. I have trainings for both mobile and a variety of other disciplines from the National Computer Forensic Institute by the Secret Service, as well as a variety of trainings for both mobile computers and other digital forensics needs from the Federal Law Enforcement Training Center out of Brunswick.
And how long have you been with the computer forensic unit at the Jacksonville Sheriff's Office and or Secret Service?
Since November 2016 for digital forensics, and I've been, I think, 2018 for Secret Service.
And in your career, have you had the opportunity to perform forensic extractions of digital devices, including iPhones?
Yes, I've done over 1,200 exams on cell phones.
And in your career, have you had the opportunity to receive, either seek through a warrant or consent and receive and review returns from third-party providers for digital evidence, including Apple
I have.
and Google?
Yes.
I want to talk to you today. First of all, you've had some involvement in this case in testified before this court before in regards to some hash values of digital evidence, but you yourself are not an investigator in this case, correct?
Correct.
So you have nothing to offer today in terms of any factual allegations regarding this case?
Not at this time.
Okay. What I want to ask you about is something defense counsel wrote in their motion regarding the ability to do what's called selective categorization or partial extractions of digital data. You know what I'm referring to?
I do.
You had an opportunity to review Ms. Nelson's motion.
I have.
And have you had an opportunity to review the 3 search warrants at issue in this case for an Apple iPhone, a Google return, and an iCloud?
I have not reviewed the warrants.
Would it be helpful to you to have copies of them as you testify today? I'm going to ask you to define some terms.
Yes.
May I approach?
Yes. Did you show, okay.
And these were attachments by defense counsel to their motion. Detective Padilla, can you describe very briefly for the court the policies and procedures of JSO in terms of receiving digital evidence from an iPhone?
Yeah, so the workflow is a detective will seize an item, bring it to our office. They will put in a request for examination along with any legal justification, either a search warrant, written consent, or implied consent are the only 3 that we accept. In the case of a search warrant, we'll review it for legal justification to see if there's any scope limitations. We'll validate that the device is listed as the device that we received. And from there, we will continue with a method of extraction based on those information.
When you receive a phone that you're doing an extraction of pursuant to a search warrant, you also receive a copy of the search warrant.
That is correct.
And do you generally review the contents of the search warrant to see that it looks sound and based on your training and experience to conduct the search or extraction of a device?
Objection, relevance. He said that he didn't review the search warrants in this case. He can't speak generally to what the practice is.
What's the relevance of that?
Well, I'm asking him about how it.
What JSO does, what difference does that make?
I can move on.
Okay.
When you perform an extraction of a phone or a device, can you explain to the court the types of extractions you can perform?
Yeah, the highest level is a physical extraction. This is a bit-for-bit copy of the memory space of the device. Below that would be a full file system extraction, which is the closest thing we can get to a file system. It's basically copying the entire contents of the phone over to another device. A lesser file system extraction would be the next level down, and it's not quite as comprehensive, but it's essentially the same thing. Below that would be a logical extraction, which is where we would be the first opportunity for us to do any kind of selective categorizations. This is basically an API call or an application programming interface. And it basically tells the phone, hey, I'd like to see the messages. Please provide me the messages, and it responds to that way. And below that would be a manual examination.
And what is a manual examination entail?
Visually looking through the device.
Are the ability to extract different levels, does that depend on the age of the phone, the presence of whether or not you have a password?
Yes and no. A lot of it has to do with that. Also, is the type of device, the operating system version that's running, and the capability and research that the software that we use, its capabilities.
When you receive a search warrant to do a cell phone extraction, unless otherwise specified, do you attempt to extract at the highest level, meaning a physical extraction?
Yes.
And in your experience, do you have the ability in the extraction process itself to put temporal or subject matter restrictions on the data as you're extracting it?
Limited, yes.
Based on your experience with the computer forensics unit, is it practical to do a partial download if you have the ability to do a full physical extraction?
It is not.
Objection, relevance. The question is not what's practical. The question is whether there was an omission to the ability to do that partial extraction.
Stifler.
She's good.
Your Honor, they've made an allegation that if the magistrate had known that there's the ability to do subject matter categorization of these devices and clouds, that the magistrate would have therefore not allowed the warrant to proceed. Therefore, the court, I want to have an understanding of the practical and real-world application of doing these searches, because analysis by the court, as the courts have said, should be a realistic and common sense approach to how these searches are conducted by officers in the field.
If I may briefly respond, Your Honor.
Yes.
So I want us to take a step back. What we said was that there was a Franks violation as to the iCloud warrant. what the officer, or the detective, excuse me, is testifying to is the ability to physically extract an iPhone. These are two different things. I haven't heard anything about the officer's ability to extract an iCloud account, which then perhaps there would be some relevance to this testimony.
Maybe I'm misunderstanding both of you. Okay, so I understood the defense to say that the information in the warrant should have been suppressed because it was overbroad in and of itself, and that this should be curtailing from the warrant stage on. Am I understanding that correct?
That's correct, Your Honor.
And then this,
Better finish.
and then what I'm hearing the state to say is that even on the front end at a global download sense, that there is the mechanism to then curtail it at the, I guess, the investigative level, even though that there might have been more information given by the magistrate.
I'm asking the witness if that's true. They have to establish that what they're saying is an omission is true. I say, is there the ability to do this? He says, yes, with limitations. It's unfair that he's not allowed to then discuss the practical limitations of what they're suggesting should have been done in this case. We're talking about an overbreadth of search. Too many categories, should not have done a full phone download. I want the witness to give context to.
A cloud at this point.
I'm going to ask them about the cloud as well. They made the overbreadth argument as to all three: the cloud, the Google return, and the iPhone, saying there should have been subject matter restrictions and date limitations on all three.
Your Honor.
But I thought it was from the warrant state. I don't know.
Allow me to clarify
Okay.
what our argument is. So we have a suppression argument that I agree with the court's characterization earlier. We also have a separate argument as to what we believe was a material omission from the warrant affidavit in support of the iCloud. And so my objection here is that the detective is testifying about the ability to extract a device that we're not saying there was a material omission about. So
Okay.
I'm.
There's no
All right,
right.
so I'll sustain the objection if you'll move. If that's your purpose, then move to what they're saying the omission is.
They also said that we should have put a time scope limitation on the iPhone because the affidavit says they're seeking communications between parties. I intend to ask this witness about where communications are found in phones and whether you are able to use a time restriction and uncover communications in a phone. That directly rebuts or allows the state.
It would be a
to
preservation
investigate
and
rather
then
argue as to the practicality of what they're suggesting and why it's not overbroad. Why does the state seek a larger breadth of time and categories in a phone download than they would otherwise if they're looking for communications?
because it will
This
fuck the
advice
phone
about
up.
where communications are stored in a phone. So the state then can argue why it was properly sought all these categories and without a time restriction.
Give me a second.
The defense has cited the Damon's case. This is the analysis the trial court took in that case as well.
Listen, this is why you do preservations.
I do have questions for the witness about Apple and Google as well.
Give me 2 seconds.
And this is also why you fucking put a motion in opposition. Where's your motion in opposition? Like, what's their argument on paper? I'll explain it here in a second. I know what he's going to testify to. You don't want to keep downloading the phone.
So I went back and read it. So where I think The argument about demons appears to be on your page 11 in your papers, okay? I was understanding that to mean when the limited search was the request to the search. Am I misunderstanding that? Like that the detective could have requested a certain time frame and limited from the magistrate's perspective what was authorized to be given from whatever provider. I didn't understand that to mean on an investigative level that somehow that could be parsed out after there is, if I'm hearing the defense, an overbreath of the warrant. Am I misunderstanding that?
It's the iCloud that you're talking about.
I think what the state is asking is on an investigative level, they could have gotten everything, and then on a searching level, they could have said, no, we're not going to look at this, or not, we're not going to produce this. Am I misunderstanding that? Because he said, we get the warrant at JSO, which I sustain the objection, but we get the warrant from JSO. I look at the warrant, I make sure it's the same device or whatever was authorized by the court. Then I can do these different levels of extraction. That's on an investigative level. And I thought the defense was complaining on a broader search warrant level.
Correct.
It all relates. Their argument is fourfold. We don't have PC.
Where is that argument?
Yeah.
The argument is they're citing the Damon's case, and they're citing specific rulings by the trial court, not the appellate court that reviewed it, which ultimately denied the motion to suppress and upheld the trial court's ruling that limited to a time or date.
It's lies.
There was 13 demons, however you want to say it.
Okay.
Provided the ones that issued to the court.
Okay.
One of them involved the search of a cell phone, as in here, and they're citing it.
For the record, guys, the Damon's court case, it only pertains to the iCloud and Google warrants are unconstitutionally overbroad in both time and subject matter. The iCloud and Google warrants. Okay, I want to see what she's saying here. He was just asked questions about a goddamn extraction. Okay, about an iPhone and how you extracted it. Are you doing full file system, or are you doing a logical extraction? What are you doing? And she's over here saying, we're not talking about the extraction. We're not talking about the iPhone. We are talking about an iCloud and Google, you motherfuckers. That's what the Damon case is about.
For the proposition that the trial, the warrant in Damon's for an iPhone had a time restriction on it. They are saying that our warrant was overbroad because it did not have a time or a category restriction on an iPhone.
Okay.
The warrant is the subject matter being sought. The evidence being sought per the warrant in the affidavit is communications. In order for the state to argue to the court why it's not overbroad, that we didn't have a time limit, we didn't have category devices, it's proper for me to ask a detective with CFIU who has experience where communications are stored on a phone. If communications are stored only in native messages, then they have an argument we should have only sought native messages. However, that's not how phones work. That's not how criminals hide criminal activity. That's not how communications work.
You can't say that.
Instead of me arguing this, the state wants to present the evidence of a detective. And part of their argument is we're not entitled to the good faith exception here because no reasonable officer executing a search would have relied upon this warrant. The fact that Detective Padilla spends all day, every day, relying on warrants such as these to perform the searches, which is the extraction, I think his testimony is relevant to the court's consideration as to the breadth of the affiant's search warrant.
That he didn't review.
They're asking, although they haven't specified specific evidence from a phone, they're asking to suppress the entirety of a phone.
That's not the grounds. Asked to be heard.
All right. So I went back. to what the question was and what the objection was, which the question was, based on your experience with computer forensic unit, is it practical to do a partial download if you have the ability to do a full physical extraction? Answer, it is not. Then the objection came to the relevance of this to this particular motion. All right. And then so you're saying that he needs to be able to explain what is practical if they have the ability to have everything. What does that have to do with my decision? What's practical in his view, in his opinion, that you said you weren't offering?
Practical is a starting word for further questioning as to why isn't it practical? Because you're not going to get the full data and you're going to miss databases with communications in them. I can ask it more directly, but I'm trying to lay a record for the court. A factual record from a witness who has knowledge as to the context of these devices, how data is stored, where it's stored, so that the state can make a proper argument why these items shouldn't be suppressed and why it's not overbroad to look into all these areas for the evidence that we are seeking.
What?
Give the court insight and context as to, if you have a house, if you're looking for a gun in a drawer, that's one thing, but if you're looking for a communication in a cell phone, it could be maintained in a variety of places.
And this is why it has to change.
Give the court context as to places it could be stored and whether or not it has metadata, if it's been deleted or stored in another manner. Okay. That goes directly to their argument, unless they're abandoning it and only want to proceed on the iCloud.
This bitch, this fucking bitch, dude, she just gave us our argument. This is what I've been saying. You can't just come into a house and get whatever the fuck you want. You have to say, I'm going for a gun, and we believe it's in a fucking gun cabinet, okay? You don't get to come to the whole house and search my underwear drawer. Okay? No, you don't. Just like the argument is you don't get to get my phone and then claim, well, yeah, there's communications in my my family portal with my doctor. There's communications in there, but is that going to have anything to do with a murder? Are you fucking high, you people?
The phone search was overbroad as to time and date and subject.
All right, Ms. Nelson. So I don't,
Give it to
let
me.
me, before I rule, I want to make sure, like you can lay whatever record that you want. This is a hearing, so I'm not so being so strict about it, but I don't want to waste time with information that you don't believe that you're arguing. So.
Sure, Your Honor. Perhaps it would be helpful if I clarify.
Okay.
So,
Am I on the right page of what you're saying? It's like 9 through 11 is where I'm finding what you're objecting to, and the state's saying you're doing more. So is it someplace else that I'm not seeing?
no, Your Honor. So my objection is that we started this hearing, the court allowed the defense to orally argue its motion. Then the state started arguing regarding suppression. At the end of its suppression argument, then Ms. Stifler raised that we made a Frank's argument, which is separate and apart from a suppression argument under the Fourth Amendment. They're related, but they are separate. This was after I'd already made my argument regarding suppression, and now we're taking evidence after I've made my argument that goes to suppression and not to Frank's. So,
I asked y'all if y'all wanted to do this.
right, and it sounds like Ms. Stifler does want to present evidence. I would just ask that to the extent that there's additional testimony from this witness that is relevant to our suppression argument, that we be permitted to respond since I've already made my
I have
argument.
absolutely no problem with that. They filed one motion for 3 devices and 2 issues. It didn't break it up in that order because the state's position is that all of this is one analysis. Or at the end, there is a Frank's assertion that I don't agree with that, but I do think the detective has relevant contextual background information in regards to these devices. The court is adept at digital evidence, but there are some courts that are not. The appellate courts might not be. The state wants to lay a proper record explaining what these things are.
Okay, I don't see any harm in it. Go ahead. I'll overrule it. Go ahead.
I'll be more targeted in my question.
Okay, if that's your purpose, ask it, okay? Ask it.
Leah, can you explain to the court how communications are stored in an iPhone?
Depends on the type.
Basically, you want to lay this record, go right a fucking ahead. The judge has already said His opinion means nothing to me. He didn't have anything to do with this case. He didn't do dick.
Communications, but it could be in the
Look at this case in Florida, and yet they wouldn't let Cyrate testify in a suppression hearing. In a suppression hearing, that he's a expert witness in their case. And they're letting somebody testify in Florida who did not do anything. What? Excuse me? I'm confused, right?
underlying application for the say simple messages. Might be a native application, it could be a third-party application, it could be a variety of applications you wouldn't consider.
In your training and experience in executing search warrants with the Jacksonville Sheriff's Office CFIU department, have you analyzed data in which you have found what will be termed communications between individuals in a manner other than native messaging?
Absolutely.
Can you give the court some examples?
Screenshots of text messages. I've seen them in gaming applications. I've seen them in regards to digital cell phones. What I wouldn't call communications, but I would call evidence of communication would be in underlying other databases like the intents and the knowledge C databases and the biome data structures. They show records of communications, but not necessarily the content of those communications. And those are things you wouldn't get through the logical extractions or select categorizations.
Did you say biome?
Biome, yes, ma'am.
Okay.
B-I-O-M-E.
Thank you.
Somebody deletes text messages or other term communications or even files, photos, voice memos, voice messages. Is there a way to potentially recover deleted data in a cell phone extraction?
Yeah, the vast majority of cell phones are predicated on a SQLite database, which is a data structure, kind of like a spreadsheet that are interlinked with each other. So you can do different queries on that. When you delete something in a database, it's not deleted, it's marked for deletion. And at some point, those databases could be vacuumed out and then cleared. So those deletions would be maintained in those databases until other processes created the actual deletions.
If you're able to recover deleted data in a database, does it always have metadata?
Not always.
Can you explain to the court what metadata is?
It's data about data. So basically it's your timestamps and your in case of messages, it might be the direction of travel. Was it received or was it not received? Or was it
From a forensic technological standpoint, two people could be communicating within a specific time frame. If they delete those communications, they might not have metadata.
Correct.
So if you put a time limitation on a search, you could be missing communications within that time frame because they've been deleted and no longer have metadata.
Yeah, if you strictly say I only went from this date to this date, the system is going to look for those dates, and if there's no dates associated with those artifacts, it will not necessarily pull those.
And when you receive a device like a cell phone or an iPhone and do the initial extraction, is there ability to go back to that device later and do a second extraction?
Yes.
Yes, you could go back to it later. The problem is that data is in flux, and as I spoke about the databases, cleaning out databases, time creates problems for us, because if you do an extraction on Monday and then do it again on Friday, you're going to have the databases are in different states, and some of that data that we're looking for, the deleted data, may be gone.
Told you. You said maybe? Ask about preservation.
Are you aware from your time with the computer forensics unit and other detectives you work with and testifying in court of a defense of, I wasn't holding my phone, it's not my phone, it's a community phone?
Yes.
And as a CFIU detective, have you been asked in cases to testify about what we call indicia of ownership of a phone?
Yes, it's when we look at the
Indicia.
data, you can always look at a text message, and we can say that that messaging app sent a message or received a message, but there's no context as to actually sent the message. Unless you're standing there watching the person do it, you're going to have some kind of attribution, and we would use other artifacts on the device to help prove that.
And not everyone's phone is in their name as a subscriber or their email address as a username in the extraction.
That's correct.
So there is the ability to obtain other evidence surrounding communications in order to determine who is making those communications at a certain time.
Yes, I'd be looking for things like what banking account were they logging into? If they taken pictures of themselves, do they do other activities that might indicate who that user might be?
Unbelievable.
Let's talk about Apple.
They got an answer for everything.
Apple is a third-party, non-law enforcement corporation, correct?
Correct.
So do they require search warrants for law enforcement to receive content?
They do.
And are the search warrants being used here in Duval County? Generally, I won't say like a template, but for the information that is requested of Apple, are the search warrants here that the Jacksonville Sheriff's Office and other law enforcement agencies use based on the legal requirements of Apple Corporation?
Yeah, Apple creates a legal guide for law enforcement, and a lot of the terminology is taken right from their guide.
And does Apple have the ability to reject a search warrant if it does not comply with their legal requirements?
Yeah, as listed in their guide, they actually have a legal compliance team that will review these warrants, and they will determine if it's, in one of their statements is if it's overbroad, they will reject, they will object, or they will deny that warrant.
You explained to the court what kind of data an Apple iCloud would encompass.
Generally, the backup of the iPhone, if it was submitted up there, will have records associated to any other device that they may have synced up there. It has messages, potentially some of the content of devices, and anything else that that user has paired with their Apple ID.
Based on your experience, does Apple have the actual ability to limit a return as to content or time restrictions if you were to submit it?
Sustain, you can back up.
Have you submitted and received search warrants and returns from Apple?
I have.
How many would you say in your career?
Too many to count.
And in that time, have you become generally familiar with the types of returns you're receiving from Apple Corporation in response to search warrants?
Yes.
Or consent or implied consent?
Yes.
And have you in the past yourself requested or have known fellow detectives to request a restricted return from Apple, as in whether it be subject matter, categories, or time?
They usually are pretty good about complying with what requested, but from my experience, what I've seen is they generally work off their own records and they will send you whatever is available to them. They don't necessarily always limit to a certain time frame.
And in terms of selective categorization or asking Apple for only specific categories of data, have you, in your experience, seen that done successfully in a return from Apple?
I don't think I've actually limited to that limitation. It's usually give me all the data associated around at most the time frame.
Because an Apple iCloud is a backing up of a phone device, is there also, can you speak to how communications would be stored on an iCloud?
I can't speak to how they store it, but it's basically a server that's connected to that user, and a variety of different ways. One of it is an iTunes backup. You've probably heard that term before. The phone does a backup and it will update and upload it to the iCloud. Because the iCloud's not it's a data storage center is all that is.
The hard drive in the sky.
Yes.
And does Apple categorize people's data for them when they upload it to an iCloud?
Can you establish if he knows?
You reviewed returns from Apple that categorize data.
Yes.
And have you any knowledge, personal or from your experience in reviewing these in general, what types of categories you have found in Apple returns?
Pretty much the same thing you'd find on the phone. Text messages, databases, I'm sorry, not databases, data structures such as messaging,
Wrong.
pictures, media.
Anything that's ever connected to it, you fuck.
Their applications that they've installed, payment records.
What's the basis of his knowledge? I think that was the objection.
Observation of returns he's received, categories he's seen, returns he's received.
From Apple? We maintaining the objection? I'll overrule it. You can go ahead. Go ahead. To the base, to the other, I heard all that. So to the other question, which is, does Apple categorize in returns? I guess was a question. I can go back up specifically.
Yes. They do provide it to us in a categorized list, so I'd have to make the assumption that they're categorizing it.
And because it's a backup of a phone, similar to a phone, are communications stored in various data structures or categories other than, for example, text messages?
Yeah, as mentioned before, it's really up to the user of the device how they choose to communicate. If they are using only communication designated devices or applications, they're always going to be there, but it's up to the subject. They could use pictures, they can use, any other kind of tool to provide communication, even though it's not designed for communication.
Like third-party applications.
Yes.
So if you have a third-party application that you're using to communicate, like TextNow, WhatsApp, etc., it would not show up in your native messages or text messages on your phone or iCloud.
Yes, those are third-party applications that are designed by other entities other than Apple.
Okay. Turning to Google, have you had the opportunity in your career to submit search warrants, implied consent, or consent to searches to Google and receive returns of digital data?
I have.
And how many times would you say in your career?
Quite a few.
Now, Google provides data in a different format than you would get from a device extraction or iCloud. Is that accurate?
Yes, but similar.
And when you parse data from an iCloud or from a device, you use generally Cellbrite or GrayKey.
Well, Celebrite is a technology that has an extraction and a decoding and a parser, and GrayKey is more of an extraction process.
When you are creating a UFED reader report, you would parse that through this parsing aspect of Cellbrite in order that it becomes readable as opposed to just ones and zeros.
Yeah, we use Celebrite Physical Analyzer, and it decodes the data, and then it parses the data.
If you were to take, I'm going to call it raw data from a Google return and parse it through Cellbrite, would it capture everything and categorize it correctly from the raw data to the reader report?
Everything, no, but everything that the program was designed to capture and decode and parse.
To your knowledge, having submitted search warrants to Google, do they also have a law enforcement guide and law enforcement portal?
Yes,
Similar to Apple?
very similar.
And do they have what they call an independent legal team per their website that reviews warrants produced to them?
They do. And as stated, as Apple does, they review it for a variety of things and will reject it or contest it if necessary.
And like your Apple search warrants, are the search warrants being used by law enforcement agencies here in Duval County and the Fourth Judicial Circuit incorporate that language that's required by Google into the affidavit and search warrant?
They do.
Have you ever requested or received a return with a temporal restriction for a Google Drive?
I do believe I have.
And did Google comply with that temporal restriction to the best of your knowledge in the cases where you've received one?
Yes.
To your knowledge, does Google have the ability, based on your experience in the returns that you've received and the warrants you've submitted, to do a selective categorization of data?
So I can repeat.
Based on your experience in sending search warrants, implied consent, or consent to search to Google and receiving returns, does Google have the ability to do selective categorization of data?
I would have to assume they do. I don't know their workflow, but I have received limited data in the past.
And for Google Drives, can you advise the judge what types of data you would find? Like iCloud is a backup of a phone and other devices. What is a Google Drive? What does it contain?
It's essentially the same thing as iCloud. It's just a different terminology they use. And you'd find the same things you'd find in an iCloud. It's everything that they have linked to their Google account. It's more specific to a Google account than in the Apple infrastructure, but it will contain the same things: messages, content of their devices, content of their photos, and backup anything they choose to back up.
And an iCloud or a phone with email
Wow.
application, same with Google, they would contain someone's emails,
Potentially, yes.
their messages,
Yes.
their applications,
Yes.
photos,
Yes.
IP addresses,
Yes.
usernames,
Yes.
bank accounts, credit cards,
All the above.
documents they may have saved,
Yes.
voice memos,
Okay.
voice notes,
Correct.
notes application,
Yes.
And whatever is backed up or in the hands of these third-party providers is what the user has created, correct?
Yes, on both Android and iOS, there are settings to determine what you choose to back up. So they could self-limit what they back up, and the Google or iCloud would not get that data.
There is some data that Apple and Google captures that the user can't create, like your IP address, for example.
Correct.
If we're talking about content, generally it's content generated by the user, like your text messages, your communications, your photos, the content of those items.
Correct.
So when Google or Apple or a phone are holding that content, it's based on whatever the user potentially categorizes as that.
Yes.
And in terms of what we talked about earlier in regards to devices and cell phones, timeline features and other artifacts that indicate the user or the possessor, because they're cloud-based, do they have the ability to hold other data not relevant to a particular individual if that individual has several devices or other people's devices connected to that cloud?
If you're asking, can it have other devices associated to that same account? Yes.
Exactly.
Yes.
You got him. You got him.
I have no further questions.
Okay.
Wilson.
Cross him up. Let's go. Let's do it.
Good afternoon, Detective.
Good afternoon.
Do you want to use this? I don't know. You're okay over there? You can see him over?
I'm okay. Can
Okay,
you hear me
right.
okay?
Right.
I want to start with iPhones. You and I had talked previously at your deposition regarding different methods of extraction, and Ms. Stifler asked you some questions about it. As I heard you explaining, there is at least a two-step process for iPhones. And what I mean by that is there is the actual extraction of the data. Is that right?
Yes.
And then after you extract the data, meaning take it off the device, that's what extraction means.
Yes,
After you do that, then there's a second step. Is that right?
there is.
And that second step can take a couple different forms, if I understood you correctly at your deposition, so correct me if I'm wrong. I heard you say today you can parse the data, right? As part of
Yeah,
step
the
two.
tool decodes. Decoding is basically putting it into a human readable format, where parsing is making sense of it.
Thank you. So we have the second step, which is decoding, which the program does for you.
Correct.
right? And then there's the first, I'll say, kind of human step to understand that data, which is the parsing.
No, the parsing is also automatically done.
Okay, so
Give it to context. If you were to decode a database of messages, it would be just a long string of messages with a variety of different contents. And you'd have to string together this table to make sense of it. When you parse it, it'll show you, like you would see it on a phone, that this message came from this person at this time. But all those elements are not kept in one spot. They're kept in various tables in the database.
perfect.
The parsing is to bring them all back together.
So once we parse, after that, then we meaning a human, can look at the data and make meaning of it,
Yes, that's when analysis would take place.
analysis. So when you extract data, you don't necessarily have to parse it, right?
Correct.
And when you parse data, you don't necessarily then have to analyze it.
Preservation.
So if I extract a cell phone and then I choose to parse it, I could just have that information sit there.
You could.
And I could also then extract, you said multiple times, from the same device,
You could.
right? And then I could take those separate extractions and I could parse both, not parse one. I could do lots of different things with them, right?
If you feel like wasting your time, yes.
Fair enough, based on your time and resources. And then even if I have two extractions, I could take one and I could analyze it and limit based on time or subject matter, right?
Yes, but you could do that on either extraction.
Fair enough. Leaving the second extraction completely untouched, right?
Yes.
So that way, if I found information that would lead me to believe that more systems within the phone or a broader time date range would be relevant, I could go back and get that information, right?
You wouldn't necessarily see that if you didn't have the information to look at in the first place.
What?
Right, which is why we have that second extraction. right?
The extraction would be the same as the first, rather than variances in the database structures.
Exactly. I think we're saying the same thing in different ways.
I don't think so.
Okay,
If you extract it here and extract it here, the data is the same. You wouldn't need the second extraction to do what you're saying over here. Over here, they're the same.
So one full file system.
thank you. So if we're talking about this multi-step process for an iPhone, still want to focus on an iPhone. I believe that you testified that once you extract the data, you have the ability to just look at, for example, a certain category of information.
Yes.
You have the ability to look at just a certain date range, correct?
Yes.
Mhm.
You also have the ability to look at, for example, communications only between number A and phone number B.
Correct.
Right? There are lots of different ways that you can cut this data.
Yes.
And you could still have the ability, like you just said earlier, to go back and look at the whole universe, correct?
Yes.
I just want to be clear, when we're talking about the iPhone in this case, you did not perform any of the steps we just went through on Ms. Gardner's iPhone.
No.
So you cannot give this court any information about whether messages or communications were located in different files in this specific case within the iPhone.
That's correct.
Let's move on to iCloud accounts. You've never worked for Apple, I assume.
I have not.
And you understand that when you receive a return from Apple, that it has different categories of information.
Loosely, it's organized in some fashion, but it is very convoluted and very hard to read in the format they provide. But there are categories, if you will.
So for example, you would typically see for an iCloud return customer information.
Yes.
You would typically see connection logs with IP addresses.
Correct.
You would also typically see something that could take the form of backed up messages, like text messages.
Yeah.
You would often see something that would take the form of backed up, I'll say SMS messages to the extent that they aren't in your iMessages. That might be a separate folder, right?
Potentially. A lot of it is buried within the backup files that are associated with those categories as well.
That is a fair point. So we have information that comes from backing up the iCloud that would be returned, right?
Well, not backing up to iCloud, backing up the device.
Backing up the device.
To the iCloud.
You would
Backing
have
up the
that
Apple ID.
category of information, right?
Yes.
You would also have other information that Apple captures, correct?
Yes.
And that other information might be metadata, data about data, right?
Yes.
It could also be information about logins to the iCloud account,
Potentially.
location data,
Potentially.
and that would be separate and apart from any sort of iCloud backup, right?
Well, it could be combined in the backup too, because the device itself does record location data, and that would be in the backup potentially as well.
And I think you testified earlier that you are aware that Apple has its own guidelines for law enforcement. Have you reviewed those guidelines?
Yes.
And so you're aware that Apple encourages anybody who submits a subpoena or a search warrant, so whether it's civil or criminal, to be as precise and narrow as possible.
Yes.
So they have the ability to respond without the entire account.
Potentially. Again, I don't work for Apple. I don't know what the capabilities are, but I have seen limited returns in the past.
Well,
You've seen limited returns from Apple.
how? How?
Did you author those affidavits?
I did not.
But you reviewed the search returns.
I have seen several, yes. Not recently.
Fucking love this broad.
Apple's been a long company with a long history, and sometimes
Shut
they
the
change
fuck
things,
up,
and they
you
routinely
lying
change
prick.
databases. I've seen in the past where you've asked for narrow scope, and you get
Go
everything.
suck a
I've
dick.
seen in the past
She
where
just
get
fucked you,
narrow scope
man.
and you get some.
Woo!
It's up to Apple
Give it up to her.
provide.
Shut the fuck up.
And when you saw a narrow scope, was it limited based on time and date?
Yes.
Did you ever see returns that were limited based on subject matter?
I have not.
So the only restrictions you've ever seen are date and time.
Correct.
And you've worked in how many? 1,200? Please, ho.
I have a brief indulgence, Your Honor.
Yes.
Yeah. This motherfucker is bought and paid. Stifler's little puppy. Get him, Kirsten.
Thank you for your patience, Detective. For iCloud returns, when you receive the information from Apple, is it in a human readable format?
Oh, gosh, no.
Okay, say more about that.
It is in a very convoluted, it's an encrypted container that comes originally to us, and it actually has to go out to the iCloud and pull this down from their system and decrypt it. And then it is put into a very convoluted process. And then we take that and load it into our analyzers in order to make it into a readable format.
A human has to.
Once you put the information you get from Apple into your analyzers and get it into a readable format, is it a similar process for what we talked about with the cell phone?
Yeah, it's the same tool and does the same thing. It just utilizes a different input.
And so as part of that process, you could limit the amount of information you look at,
Yes.
and you could still go back to that information later and look at the entire universe. Is that fair?
Say it, Daddy. God.
I think we covered this about iPhones, but just to be sure, for iCloud accounts, when we talk about limiting the type of information that you could look at, that could be by date,
Yes.
that could be by people or users,
Yes.
right? That could be by keywords,
Yes.
that could be by locations, like geotags, for example.
Yes.
That could also be by phone numbers, right? And the same is true for cell phones,
Yes.
right? Let's talk very briefly about Google accounts. When I talked about the ability to limit what we look at from Google, I want to ask you the same set of questions. When you get returns from Google, are they in a human readable format?
It's better than Apple's, but it's very convoluted as well because they have their own proprietary format. It is human readable if you can figure out how to parse through their data manually. However, it suffers from the same problem Apple has. It's basically just a data dump. And so you'd have to use some kind of analyzer in order to make sense of it.
And once you do the analyzer, as you just said, and it's in human readable format, are you also able to then parse the data?
Yes, same rules apply.
So it's exactly the same as what we just talked about with the iCloud account.
It is.
And that's exactly the same as what we talked about with the iPhone.
Correct.
I'd like to fast forward a little bit and talk to you about the process for when you receive a warrant. You testified earlier that when you receive a warrant, you look it over before you look at the device to make sure you're in compliance with the warrant. Did I understand that correctly?
Yes.
And once you review the warrant and you go into the device, we can use a cell phone as the example. You're going to review the cell phone. If the warrant says something along the lines of any and all information about who owns this cell phone, are there any standard operating procedures in the department that give guidance to what you can or cannot search?
No, because that's a very subjective term when you say device identifiers. It could be as simple as the device ID, the account information, but you also have to look at the context of the device. What activities was that device being used for? You're going to look at what user accounts to other third-party applications are out there. So you couldn't just say it's just the device identifier you're looking at. It's the breadth of the devices. who's using the device, what applications are there. Like take a banking account, for example. Who are the user accounts associated to? So you'd have to look at all the totality of all that kind of stuff to really make a concerted effort to say, this is the user.
So if
What?
I understood your testimony earlier, again, using whose device is this as our example, that could mean you're looking at lots of different folders and files. Is that right?
Potentially.
Potentially. Let's name a few if you're trying to identify whose device this is.
Like I said, I'd first start with the ownership of the device. Who's the account holder? It'll have, an email address, and it'll have the phone number and that kind of stuff, the serial number, the IMEI number, the MSN number of the phone. All those are your basic subscriber information. And then on top of that is, if I'm trying to attribute that to a particular person, I'm going to be looking at financial records, social media accounts, third-party applications, where are all the user accounts. It's safe to say if every user account's the same email, that it's probably the same person using the phone.
Might look at if they had medical records stored on their
Yes.
phone, right? You might look at if they had copies of driver's licenses stored on their phone, right? So pictures, emails. You would essentially look everywhere that you could find information on the phone. Is that fair?
Potentially.
And I think I heard you answer my question, but I want to make sure that I heard you correctly. Are there standard operating procedures at your department for where you can and cannot search as part of that process?
There is not. There's best practices that we adhere to, but there's not a standard operating procedure. Every device is different. Every case is different.
And so if a forensic examiner is reviewing, again, we'll take our cell phone, there aren't any specific guidelines for what he or she should or shouldn't look at as part of that process.
No, but you gotta understand the vast majority of the stuff that we look at, we're extracting the data, putting it into a reader format for an investigator who's linked to the case to review. I don't know the facts of the case, so a phone number may be relevant. I wouldn't know it. So I'm not looking at the data. I'm passing it off to the investigator to look through the data.
And does the investigator have any standard operating procedures to follow if you know?
I do not know.
You don't know?
No, I don't think there's anything in writing. It's based on the case. If you're looking to determine ownership, you're going to look one way at your leads. If you're looking at, pictures of drugs, you're primarily looking at photographs. I mean, it's going to be case specific. So there's not really a standard operating procedure. It's more case driven.
She just walked him into that trap. Oh my.
Mr. Carodi reminded me that I forgot to ask you some questions about the analysis piece of an iCloud account, a Google account, or a cell phone. To the extent that your answer is different based on the device, please let me know and I'm happy to ask the question differently, okay? So once we get the information into human readable format, we talked about your ability to then focus in on certain categories of information, right?
Yeah, the whoever's looking at the data has the ability to filter down to whatever they feel like filtering to.
And as part of that, can I call it the filtering process? As part of the filtering process, that could take anywhere from a couple seconds to a couple minutes, right?
Take longer depending on the amount of data that's in there. Yeah.
Sure. A typical cell phone, it's not going to take weeks.
For the filtering or for the processing?
For the filtering.
It should depend. Depends on how much you're filtering. If you're only wanting to see a particular phone number and you filter it, it takes seconds. But if you're wanting to filter on 80 different things, it may take you multiple steps of filtering to get to where you're going, and that could take weeks of looking through that data.
For the computer program just to run the filter, let me be more precise. Approximately how long would that take on an average cell phone?
It's almost immediate. It goes through and looks through the data. However, most of the filtering is either a single filter across the entire data set or through a certain artifact, say a messaging app. If you just want to look through the messaging app and you want to say, give me all these phone numbers, it'll show you just that application. But if you wanted to look for that phone number across the entire device, then that would be a different search. You're not really saying this phone number and. It's usually one or the other.
No further questions. Thank you, Detective. Briefly.
Okay.
This is just a couple questions in response to what Ms. Nelson asked you. If you were to limit a search by filtration, however, through Apple, iCloud, Google Drive, or phone, or so only specific keywords, that presumes that those keywords are legitimate.
It presumes that those keywords are actually in the device and or valid to the case. Yes.
So if I ask you, Detective Padilla, will you search this phone for the word murder? That's presuming that the people talking about murder use the word murder as opposed to a code word.
Yeah, it wouldn't use any kind of aliases for the word murder.
Or if we're talking about specific communications between two phone numbers, that's presuming that they're communicating with someone who's using a phone registered to them or a known phone number.
Or using the native phone app. If you're using another third-party application, there might be a different phone number associated.
So if you're using Snapchat to communicate, or social media, or WhatsApp, or any third-party provider, or gaming application,
Hit her and you can unhide her.
you search with a particular phone number.
It more than likely would not come up.
And if you were looking for communications between individuals based on their names, that would presume that the person using the device has stored that person's name as their, what we call in this line of work, government name, correct?
Correct.
There are ways, in your experience, people use devices to communicate in non-traditional.
Freckled Gemini, what are you doing?
Obvious manners. Is that fair to say?
Absolutely.
Thank you, Your Honor. No further questions.
I have a couple. Give me a second. I just want to make sure I'm understanding your testimony. Okay.
Try right now, Miss Mary.
I think where I got a little confused was, so there were questions about your experience with iCloud accounts and then the return back. I think I heard two different things. So you have experience where there have been limits on the warrant and Apple has sent back curtailed data, you said, that's hard to read. So you have had that experience. So if it is sent out in a limited fashion from the issuing court, you have gotten returns back from iCloud. Because I heard you say Google, but I heard, I think, two different things. And I just want to make sure what your true answer is.
It's hard to tell what they limit because they don't come back with a, here's what we gave you. It's basically a data dump. But you can kind of look at the date ranges and go, okay, well, these only start here. So it had to have been limited, is what I think I'm trying to convey. They don't say, we only gave you the text messages from this time frame. They basically send you a copy of the warrant that comes with it, as well as some delineation in there. But there's really not a lot of, this is what we limited it to.
So how are you deducing that fact? So you're saying that you get the information, then you look at the warrant, and then you look at, once you extract it, you have those two time frames, and you say, oh, they must have limited
Yes.
based on the warrant.
Right.
That's how you're deducing that information.
Absolutely.
Okay. And then I also heard you say that you have, I guess, reviewed the warrant. It's asked for a narrow or precise time frame, and then it says, I have the experience to where the warrant says something narrow, but you get everything.
Yes. That has happened.
Okay.
To clarify a little bit though, if our warrant is specific to a time frame and we get more back from them, it is my responsibility to limit the report back to the investigator. Because as I mentioned, I don't examine them for the most part. We might interpret data for the investigators, but we're not looking for evidence because I don't know anything about the case. But if the warrant says this date to this date, when I
And you get everything.
report, I'll get everything from the extraction or everything iCloud gives me. I will limit the date range to only the artifacts that contain that date range or anything that does not have a date associated to it, and that would be presented to the investigator. So they would not get anything that would be outside of that scope.
And so I think that's where I might have stopped you. So that's what you're saying. You look at the warrant, you look at what the extraction is, and then you only provide what the warrant gives you authority to provide to the detective,
That's correct.
even if you get everything.
Exactly. Because we represent the data, not the investigation.
When Ms. Nelson was asking you questions about the multiple steps, so I only got to 2. So it's extraction, and then there are 2 automatic things that occur. I just want to make sure I'm understanding you. There's decoding and there's also parsing.
Yeah, and in this
Is there another step?
analysis, but that's
Analysis.
That's the investigator's role. There's also interpreting of the data that would come back to our unit if the detective says, hey, I want to present this piece of evidence. Can you help me make context to where it came from, how it got on this device? And we would offer our services to help interpret that data.
Okay. That's all I had. Are there any questions based on mine? Okay, thank you. All right, let's take 10 minutes. Okay, court's in recess.
What that guy's testimony just proved is everything I was saying about, yeah, you can go get the information and then you can then, after you have already extracted it, like all these human things have to take place, and you can only search, you know, X, Y, and Z things. And it's to sit here and say, I cannot believe that Stifler brought him in. I mean, he tried at first, and then, yeah. But it's all, how it works is when you download a phone to extract this data, it comes in like huge Excel files. Okay. All the different folders for whatever it is that you're, like, all the different categories. And then also, like, it comes in PDF form. Okay. And that happens, though, it's a human click to go into these different subfolders. So, like, for example, if I was to plug in right now an external hard drive that I have, and I go into Dr. Drake's phone, okay, you can look at SMS, like text messages, SMS. Then if you have like Marco Polo app, like all these different categories, his location, his Gmail app. So then it was like his Life 360. Yeah. So, to sit here and say that you can't, it's a lie. It's an absolute lie. It should be, and this is what Cyray's talking about. Going and getting and preserving the data is one thing, so that you would have it if you are able to one day get probable cause. Okay. So you preserve it. You preserve the data. But her cell phone wasn't in any of the geofences that they were interested in. I mean, all of this is it's a mess. But to sit here and say that your iCloud account, it could be multiple devices that I set up, right? Like my phone right now, I was just looking at it. My iCloud account, I went to like the Find My Phone app. It says my different devices. Hold on one second. Devices. I have AirPods on here. To a Beats Studio Buds. I have 1, 2, 3, 4, 5, 6, 7, 8, 9 iPhones. I'm sorry, 8 iPhones and 1 iPad. And then if I go into my iCloud account, it's like that's like your iTunes and shit like that. So it would have been any device that I've ever logged in, that I've ever used with my my Apple ID, my iCloud. I mean, come on. I could potentially have, you could have spouses and shit on there if you're syncing to if you're syncing your phones together. You know how you can tell that a lot is when somebody is continually to sync their phone and they have like 5 mic Fs. Okay. It's like, what? Well, you have multiple phones that you're syncing. And so it's putting, each time it's doing it to that new device, it's putting it in your phone again. It just goes back to this. It goes back to, these are all fishing expeditions. And you're using this loophole. And I have no idea why it ever even became even a loophole. Like your phone, it's not like back in the day. Like these are smartphones. These things fucking, they think it says something that we don't even say. And then it's entered in your search history and, whatever. It hears my conversation that I'm having about whatever. And then that starts popping up in ads. I mean, like our laws and cases, and they need to catch up with the times. Okay. I'm sorry, but a 1984, 1972, 1940 case when there's no fucking internet. All right, give me a break. Okay, then we get the internet. Okay, now we have AI, we have smartphones, and we don't use our home the same way that we did back in the 90s and 80s and 70s and 60s. That's why people aren't breaking into people's houses anymore. Nowhere near like they were back in the day. Right? Because what is kept in your house anymore? Like, what are you breaking in and grabbing? It's all the cyber crimes. Shit, you steal someone's phone. It's wild. Look at all the different apps that you have on your phone, and every app is tracking you. Okay. Facebook, Instagram, every time you're getting a push notification from an app, when it sends you that push notification, it goes in your timeline. And so it date, time stamps you, and location. If you have fitness apps, if you have your car app to your phone that you could like start your car and shit like that. Trying to think here. Think about your Park Mobile app. You guys you know how we don't put any like change in meters anymore, and you have to like scan, you hit your app, and then you're paying for your 2 hours via your mobile app with your Park Mobile app if you're never downtown. Well, we use it here. Guess what that app would tell you? Any car that I've ever put the license plate in to park is in my phone. Your banking apps. All your rewards. Anybody that's like all about their rewards, that's all in here. Obviously, Google Maps, DoorDash. Think about that. DoorDash, anywhere that you've ever received a DoorDash, because you can change your location on where you're accepting a DoorDash. Like, you don't think that it's a privacy, like where I was hanging out and doing whatever on, 2 years ago, 3 years ago, because I got a DoorDash sent there. Maybe I even send one to somebody, because you can DoorDash. I could DoorDash any of you guys right now a meal. That doesn't mean I'm there. Okay. But think about if you were to use that in an affidavit, okay, and act like you reasonably believe that I accepted and I was physically there and accepted a DoorDash from that place and I was physically there. And then knowing you knew that I wasn't there, right? And that there was other information that told you that, but you can just go and claim ignorance in front of a magistrate. Eventually, if it would ever come out. And now that's what they're trying to do here, is say that, well, the affiant had, well, why are you calling this asshole to the stand? Because he wasn't the affiant for anything that we're here for. So why are you calling this guy? And that's why she asked those questions there at the end. Like, you didn't apply for any search warrants in this case, right? None of the search warrants that we're here for, you applied for. So why are you calling somebody to the stand? Didn't do the work. What he did is the work after the search warrant was obtained and the information, like it's like, here's the phone. Okay, here, go give it to this dude. And this is all what Psy is trying to change in the world. Okay. Like, I just think it's unconstitutional. Where is, like your Target app, Expedia, like Life 360, I mean, you name it. Dropbox app, Zooms on your phone. I'm trying to just look at all these different, your Reddit app, Yelp. Hulu, Prime, Netflix. I mean, your passwords. It has an app that you can store your passwords. Like, you should be able to get, and they're asking physically for these passwords. I think it's crazy. But all of these apps always ask you to share location. And so just remember, if you're sharing location with any of these apps, okay, when it asks you that, you're usually getting a push notification. And so it's going to record on your timeline. And then it's sharing your location. So whenever you're actually using the app, immediately when you hit it, automatically that's going to come up on your timeline as a location. And so, like, that's how, when I was navigating and finding all the shit that I found on Brian Drake, right? And Jennifer Drake on their phones, dude, I was going into so many different artifacts to do all of that. Okay. And at least, like, Brian Drake's a victim. Okay. Jennifer Drake gave consent. But lazy people, I guess, suck, because the information was there. I guess you just had to do some research. YouTube app. But what you can do is, if you have an iPhone, you want to go into your settings, hit settings, all your Wi-Fi connections, your Bluetooth, anything that you've ever set up with, like, when you hit Bluetooth, it's going to see all like that shit. If you hit Control Center. Allow access to Control Center within apps. When disabled, you can still access Control Center from the home screen. So you can reset the Control Center. You can wipe your phone. I highly recommend it. You go to privacy and security. You hit that, and you're going to see location services. And it says that I am sharing locations with 41 apps, only when I'm using the app, though. While using, I have to be physically using the app. If your app is sitting in your background, and then it lists what apps. We were doing a test to see if, let's say that I was to get a phone call right now. Okay. Am I able to, since the phone is like, if I'm able to answer it, okay, could I answer the phone? And then because I answered the phone, am I able to then physically get into it and start like doing stuff with it? And I was explaining this actually to Josie, and I was like, no, you can't. You can't use calling somebody as a way to get into their phone by answering the phone. You could answer that call, okay? But if you were trying to then, like, after you answer the call, to like then get in and send a text message or look at a text message, it's going to ask you for the code. I'm curious because I can't remember if back in the day, if you were able to answer it and then still get into it. Your weather app. You guys have like your weather app on your phone? That fucking shit tracks you. So this has to change because these circumstantial cases, fuck all that. Like, you can make a circumstantial case against anybody. Especially if you don't need a nexus. Like, shit. All right, we're back in session. Let's do this. Oh, what's going on here? Here we go.
In this case, State versus Gardner, the iCloud and Google search warrants at issue here do involve some form of limitation. There is a beginning date, there's an end date, and by the returns, it appears that the search was conducted within those guideposts. I want to talk a little bit about some of the analysis in the call, and I've provided Your Honor a binder of case law that I'm relying upon, as well as filings in State v. Damon's case, and a case here in the Fourth Judicial Circuit, State v. that have taken this issue of how modern courts interpret the Fourth Amendment when it comes to digital data because of the nature of devices and phones and iCloud and Google returns and the types, enormous breadth of data and information that is captured in these that distinguish them from what we consider a traditional Fourth Amendment analysis of the search for tangible property in a fixed place, search of a home, search of a car. But in the call, the court gives a lot of analysis and insight into this. The courts themselves struggle with how probable cause and particularity apply to information that law enforcement collects from a cloud account. And note that it would be unsurprising that police officers would struggle as well. And ultimately, I will begin with the end, which is no matter what the court thinks about the Fourth Amendment and cloud data and temporal restrictions and selective categorization, ultimately, all of these cases, all of these courts, Your Honor, should land in the same place, which is that these warrants are sufficiently articulated. Like the wiretap application, there is an extensive discussion of the objective facts of this case. There are facts in these warrants not only about their participation in a premeditated murder, a child abuse, a conspiracy, but also an articulation that these individuals, based on what the applicant knew at the time seeking these warrants, were using alternative means of communication to speak to one another about the death of Jared Bridegan, the possibility of financial transactions, arrests of individuals. There are articulable and specific facts outlined in here that several of these individuals, Ms. Gardner, Ms. Jensen, perhaps Mr. Biggerstaff, Mr. Fernandez-Saldana, are talking on wire intercepts about their phones being tapped, about using FaceTime, about looking for other ways to use other phones to communicate, about going to a neighbor's house to use their phone to communicate. So in seeking communications, the reason I had to testify is to give this court an idea that people who commit crimes don't use text messaging, their native messaging to text their co-conspirators from their own phone number, in their own name, to their own name, saying things like, hey, want to go commit that murder today? That defies common sense, it defies logic. The reason the state seeks and should be allowed to look for information in places other than the selective categories that defense would like us to is because people tend to hide evidence of wrongdoing. They tend to delete it. They tend to circumvent traditional methods of investigators finding communications. A phone and a Google return and an iCloud are based upon what the user does, how the user defines someone in the phone, how they tag them, how they name them, which applications they use, what they delete, what they keep, what they screenshot, what they send, what they record on a voicemail and send. So it's not unreasonable, given the government's compelling interest in investigating homicides, that an investigator would be able to look in places other than native messages or keyword searches for murder between two known phone numbers. The same way as if Your Honor were to give a search warrant to a house to go look for a letter about a murder, detectives can look through every piece of paper and every filing cabinet in a house, regardless of whether it's in a drawer that says kindergarten report card or medical records or tax documents. In some of the cases I've cited for Your Honor, is because we, the state, and investigators should not rely on the defendant's own categorization of their evidence of wrongdoing. We should not be stuck. We should not be handcuffed because they have taken steps to delete or hide or circumvent traditional investigations or use other ways to communicate that are surreptitious. The affidavits in this case, and Your Honor has to do a case-specific analysis. The affidavits in this case clearly establish probable cause that these people are involved in a premeditated murder for hire that would necessarily involve relationships between parties, long-standing relationships, communications over time, and there is evidence that the applicant relates to the magistrate, they're taking steps to hide their communications and use other mechanisms of communicating. The limit that the detective put in the affidavit is objectively reasonable, and it's reasonable, and this court can defer to the magistrate's determination that it was reasonable. Based on the fact that you're talking about in this case, not in any other case, not in a case like we have cited here where we're talking about a prostitution ring or a spur of woman robbery. We're talking about relationships between individuals, motives that span years and months between what they want to consider as innocent relationships. Well, those have historical significance, which gives detectives reasonable grounds to look into that. If Ms. Gardner, as it states in the application for these warrants, is saying on a wiretap that she has previously met Henry Tennant, being titled as the announced as the killer of her ex-husband, then certainly it's reasonable that police would want to go back further than the day before this murder to see, in fact, that there is a historical relationship or communication or connection between Ms. Gardner and Mr. Tennant. And sometimes the absence of data is indicative of guilt as well. If they go back in time and see there are no communications that have an instant explanation between these individuals, or there are no similar messages between people not connected to this plan that defeat an instant explanation for some of the communications that are happening or not happening, or the communications that we see or don't see. And recall, that is exactly what the court says. The court talks about
than 2 types of narrowing you can do on a warrant. And recall it by its stated in the opinion, says it expands the analysis of Blake, which is cited in the defense motion. Blake comes in 2017, McCall is 2023, years later, as our technology is developing, how we investigate cases is developing. They talk about how, in this case, an individual was participating in a game of poker who felt that he was losing. He called up some individuals to come commit an armed robbery and the individuals he's playing with. And the court contemplates that even though it seemed to be a spur of the moment crime, it makes sense that they request a larger time frame for a file return because there's a pre-existing relationship between this individual and the people he called who came in and committed an armed robbery at his beck and call. They said it was reasonable to look into some co-conspirators or co-defendants' pre-existing relationship to establish his knowledge, participation in this robbery. It is not unusual to believe such a relationship will be reflected in the data stored inside McCall. So McCall, to me, is the one that the court should look at the most. It's one of the most recent cases. It is specific to a cloud account. It talks about a fact-specific analysis that even in a case like this where they know that the communications between that data are not going to be on the cloud because of the way it was backed up in this case, that because of those relationships, it makes sense to go back to the court. It also talks about how a subject matter or categorization limitation makes very little sense. And I understand the defense point that this is a broad search warrant and we've gotten all of data, but I will tell the court, the state of Florida is not saying that you're holding an arrest warrant affidavit and arrest warrant that says entirety of ICloud is property being sought. There are specific categories outlined in these warrants. Do they cover the majority and bulk of the data that would be contained in these devices or clouds? Yes, but they are specifically delineating. This is not a mere fishing expedition, and what they're looking for is communications, and they are specifically discussing categories of data that would include communications. They specifically say, we're talking about the iPhone warrant, number 10, communications between parties relevant to the offenses, concerning payments relevant to the offenses, related to the offenses. They're specifying as best they can, but as the McCall court understandably realizes and outlines is that in today's world, culling digital evidence is nearly impossible. You're talking about subject matter because of the way people store data and the way people communicate. In the United States versus Blake, the case cited by defense in their motion, that court says that they're talking about social media, Facebook warrant, that it's not open and shut whether this was overly broad. And then they find that, if it's not open and shut for these courts and we're doing a case-specific analysis and intelligent magistrates and intelligent appellate courts can disagree, then it's unfair to dock the officer for relying on a judicially approved warrant on these issues. The whole analysis of probable cause, it's not a hyper-technical consideration, it's not a legal technician, it's a real consideration. A real person reading this warrant and conducting search based on it would not think these are facially deficient because magistrates themselves can't always agree. But it is worth noting as well, Damon's is cited by defense. In Blake, McCall, and Damon's, the warrants before the court are very different than the ones that are in this Gardner's case. And I've provided the remainder of the filings, since Nelson cited a portion of the trial court order in Damon's. I have provided the actual trial filings from that case, including the suppression motion number 1, which is to a phone, and suppression motion number 3, which is to an iCloud. Those include the warrants that issue in that case. When Your Honor reads those warrants, you'll see a vast difference in how thorough and in-depth those ones will compare to the ones we have here. I mean, in most of these cases, the court, from McCall, they didn't put any kind of restriction on the iCloud. They didn't put a date restriction. They didn't put a content restriction. They asked for the entirety of the iCloud. And the court said that was still proper. They received 2.5 months just based on when it was created. They said that was still proper given the coexisting relationships. But here, the state did act in good faith. The officer did put a temporal limitation in those warrants. He even put a paragraph in, I know Ms. Nelson called it the attempts to save the efficient warrant in her motion, that your applicant understands this is a longer time period than would normally be requested for digital data,
However, based on the nature of this case, directly, based on the nature of this case and the presence of the co-defendant, the fact that we allege this to be a murder for hire,
What are they doing?
there will be relevant information in a longer time frame, just based on the circumstances of this case, the number of participants, and the evidence these people are communicating over time before and after the homicide, and talking about communicating in ways to avoid law enforcement detection. She cites forward information, again, that court there held that a failure to limit it in any material way, with no dates rendered it overbroad. Here we limited our dates. In Irving, which is cited by defense on page 12, the search warrant went back to the inception of the account and had no limits for dates. Here we have limits for dates. So their cases are distinct. Here, the applicant done exactly what McCall and Blake have required, which is trying to make some kind of meaningful limitation while still getting the evidence which they're seeking that they would be entitled to given the facts and circumstances. I cited United States versus Brooks, 427 Federal 3rd, 1246. That's a 10th Circuit Court of Appeals. It's talking about, in this case, that digital searching is as much an art as a science. And that's the purpose of detective media, again, that we're not looking through financial documents where you can control F on a PDF and find what you're looking for by keyword search. We're talking about sophisticated individuals who are using code words, using applications, hiding their communications. So by nature, where we're looking is going to be broader. U.S. v. Burgess, 576 Federal 3rd, 1078, 10th Circuit, talking about sometimes because electronic files can be labeled, relabeled, that we have to look at all files, sometimes to find the ones we are seeking. U.S. v. Farlow, 681 Federal 3rd, 15, that is a First Circuit Court of Appeals case which discusses that computer files can easily be renamed, file extensions can be changed, and therefore sometimes the investigator or the searcher has to look in more places than one to find what you're looking for. And this is really to look for what the communications at issue. The identity of the individual making a statement, the identity of the declarant is always going to be relevant to an investigation. I have been on homicides, I know this court has done trials where people bring forth defenses of that may be my phone, I wasn't holding it, you can't prove that's my phone, somebody else was using it at the time of this homicide, phones where people's names aren't the subscriber name. Times when individuals come up with a defense of it's a community phone, it's being passed around, somebody else is holding it. So indicia of usership and ownership and possession at the time those communications are being made is always going to be relevant.
Then you have to state that shit. I'm so sick and tired of them asking after the fast, like after the case, after the fact, I'm sorry. Like, then you write that in your fucking affidavit.
How else is the state of Florida going to get a statement into evidence of a party opponent without establishing that the party opponent was using the device at the time of the statement? It also provided the court was
How am I supposed to get a party opponent in it if I don't do this? Bitch, then you don't get it in. That's what happens. What did they do in 1980 when there wasn't cell phone jukebox? I mean, this is absurd.
cases regarding that type of analysis. State v. Arnago, 973rd, the 3rd DC of Florida. That case actually involves a physical search. Our officers were trying to determine in a grow house for marijuana, the individuals inside who was responsible, who they were in charge, and they collected cigarette butts, beer bottles, and fingerprints that were located in close proximity to marijuana plants. And the court there found that evidence to ascertain identity is reasonably within the scope of a search warrant, even if not specifically outlined. So even if we're not specifically outlining some of these things in the warrant, which they are for the most part outlined, any indicia of ownership is always going to be relevant, is always going to be reasonably contained within evidence. This person is making these statements. We're asking for communications between Gardner's co-conspirators with the communications between Ms. Gardner and her co-conspirators. US v. Bass, 785, Federal 3rd, 1043, it also discusses indicia of ownership that the police can seize more when it's unclear what format evidence would be in. Again, for looking for communications, we're not limited to data messages. Communications can be in multiple types of formats. United States v. Solomon, 742, Federal 3rd, 221, that's the United States District Court of Connecticut. They discussed that law enforcement has a strong interest in determining who owns the phone or is using the phone and linking evidence to a particular individual. And this all cuts exactly to the argument they're making, which is establishing a nexus between the individual and the evidence being sought. US v. Richards, 659, Federal 3rd, 527.
We're asking you to state we're asking you to state a lot of things. We're not, you're not even stating, we're asking you to state, of all the allegations that do concern Shanna Gardner, nearly all described conduct occurring after the murder, and before that, it was that she was married to Jared Bridegan at one point, and she's married now to Mario Saldana. You have zero allegations against this woman. There's all these conversations, and they do not include her. There's all these relationships, and they just don't include her.
The U.S. Sixth Circuit Court of Appeals, that detectives doing a digital search would not know the format of a server at the time of the search. So there would be multiple different servers. We found that was not all fraud. So the case law is clear that a reasonable limitation is sufficient. They favor a temporal limitation because all this case law recognizes that there are multiple ways you can store digital information. If you're searching for a gun, there's only so many places you can find it.
Oh, shut up.
Digital evidence is not tangible anywhere. Therefore, you have to look more places to find it. As long as you're doing so in good faith on the validly articulated and
She said there's only so many places you can hide a gun. Bitch, are you serious? Up your vag? Up your vagine? I can't. I'm going to drink. I have to drink. I can't. Cheers.
So in demons, I would love the court to look at these suppression motions with the attached warrants and see that they are much less detailed, much less specific, much less articulated than the warrants you have before you. And in that case, the court imposed some limitations because none were imposed and severed parts of the warrant, and the appellate court upheld it. Same with McCall, same with Plea. So those appellate courts allow the evidence to be used at trial with warrants that are far less detailed and sufficient than the warrants Your Honor has in front of you today. Lastly, I understand, although not controlling, Ms. Nelson gave you a magistrate's order from Broward County. I have provided a motion to
Vagina gun.
Consideration of a circuit court decision here in the 4th Judicial Circuit, State of Florida versus Henry Landon. It discusses Meta, which would be a Facebook return, and similar issues where the defense was attacking the warrant as overbroad and not particular. That one did include a time limitation, and the presiding judge in that case.
You put it in these materials. I haven't looked through this binder.
Yes, sir. Everything that I'm referencing is in the
Okay.
binder and has been provided to the defense.
I haven't had a chance to look at that.
That was in Division CRH, and on November 2nd, 2023, the order denying Judge Brandon wrote, asking to look through all data for evidence relevant, in that case to a kidnapping assault, is not any different than looking through an entire file cabinet that contains all sorts of business files to find evidence that pertains to a distinct financial fund. The state was not required to ask Meta for discrete pieces of data or specific records. Tying the request to a specific account and date range where applicable is enough. On his motion for reconsideration of order denying for reconsideration, the judge also found that the police.
You guys, they allege no facts placing Miss Gardner at the scene of the murder in contact with the alleged shooter on or around the night of the murder, involved in planning the route, or connected to the weapon used. Don't you think that those are pretty important things? The affidavits are replete with allegations concerning other suspects, Mr. Fernandez Saldana, Mr. Tennant, and Mr. Biggerstaff. But those allegations cannot be imputed to Miss Gardner by association. Like, bitch, that's your man, girl. We got you. Okay. What? That's like saying we could take down drug dealers' girlfriends because they live with them. And she told him to be a drug dealer and go make it happen, boo. Because we're going to pay our bills. So she conspired to sell drugs. You see what I'm saying? And that's the type of shit I would be saying in these fucking suppression hearings.
Relied in good faith on the warrant issued, and that noted that the police did not skip the subject matter limitation in the warrant out of some nefarious plot to get more information than the law entitled them to do. Instead, they did what they always do. Use the basic form for these kinds of warrants. There's no misconduct on the police, part of the police here to deter. They acted in good faith, applying the warrant according to standard procedures, including those imposed by Meta itself, and received and reviewed the respondent information in good faith reliance on the judicially approved warrant. An officer, ultimately, this is the state's position that these warrants are sufficiently particular, supported by sufficient probable cause, create a sufficient nexus between Ms. Gardner and the items being searched, and Ms. Gardner and the crime alleged, premeditated murder. We believe the time frame is reasonable, given her pre-existing relationships with the co-conspirators and her pre-existing relationships with the victim, and the evidence of motive developed historically over time. But even if the court were to assume there's not probable cause here, which nobody can see, this is the epitome of a good faith case. No objectively independent officer would read these warrants and think that they were not supported by probable cause, given the breadth, depth, and length of discussion in here. In fact, it was approved by an officer, by a magistrate. And what Detective Plea testified to is there's even the third party layer. These officers are trained that when they submit search warrants to Meta or Apple or Google, that they are told by those third party providers they have an independent legal team analyzing the search warrants and will reject them for non-compliance. So the officer receiving this and doing the search is aware that there is an affidavit.
Those are bots. Okay, are we going to start bringing bots in? Because why aren't we subpoenaing Apple then? Why aren't we subpoenaing the people that are saying that they're on these legal portals? We need to start bringing them the fuck into court. You understand that, right? Like, that's like saying fucking YouTube AI is over here saying what violated terms of service. Why do you think shit gets overturned all the time? Because they're fucking AI bots.
Warrant of breadth and depth, outlining with specificity what they're looking for, where they're going to look for it, for how long they're going to look for it, sent to the third party providers, accepted by the third party providers, after being signed by the judge. Given the totality of everything before the court, we would ask the owner to deny the defense motion.
Can I ask what the plan is, because Mr. Fernandez kind of delayed the Franks. Hearing.
What?
Is that what you all plan to do here? Is that?
I would say for the Frank's assertion, given Detective Padilla's testimony, that theoretically it's possible, but no one really knows because Apple has never explicitly said it in their law enforcement materials, and he has sent specific limited warrants to Apple and still received full data dumps. I think the defense is
Isn't that fact specific on the investigator submitting information?
Well, before we have a Frank's evidentiary hearing, the burden is on the defense to present.
Right, that's what I'm saying, like, so.
I would say haven't met their burden, so there's no, you can summarily deny the request for Frank's at the end. They haven't proven one, that that's even true. Two, that it's material that the problem caused the entirety of the affidavit, or three, that the officer intentionally left it out of the.
Maybe I'm not being on, what my question is, I thought there was was a deposition that needed to.
That is a, yes, sir, that is, Mr. Dry's petitions are separate from this.
You think, okay.
Well,
I
I think
agree.
so. Yeah, I can hear Mr. Carter.
Sure.
He's on Zoom, right?
No, it's a different Zoom setup, so that
Oh,
others
understood.
can talk. Unless you all can correct me if I'm wrong, I don't think anyone on Zoom can talk.
Judge, can you hear me?
Oh, I can, okay. Yes, I can. Well, I'm under a long pressure. Hello, Mr. Dreiser.
Hi, Judge. I believe our issue is distinctly separate than this issue.
Okay. You agree?
Yes, sure.
Okay. All right, thank you.
Yes, ma'am, thank you.
If Ms. Stigler's finished, Your Honor, I'll make the
Yes.
argument. I'll pick up at the end with the Frank's hearing. I disagree that we haven't met our burden. I think we actually met our burden through the, who testified unequivocally that law enforcement knows they have the capability to not only request targeted information from Apple, from Google, but they also then, once they receive that information, they know that they have, meaning the forensic folks, have the ability to filter before it ever goes to the investigative team. Detective video is very explicit about that. Not only that they can get it separately, but then the forensic unit itself could narrow that data consistent with any sort of search warrant before it ever goes to anybody with knowledge about the case.
I guess I have a problem with that because he was speaking kind of in generalities and I'm supposed to take that kind of general, I don't really know I don't know what to use that for. But I mean, so you're like, so he's saying in a general sense, but I don't know necessarily from this perspective, according to this case, that is a case specific finding. So you're saying I should take his testimony, apply to this case, that is a possibility, so therefore.
So if the court, our position is that in terms of whether the defense is entitled to a Frank's hearing, the answer is yes. And the burden is on the defense to show that we are entitled to one, and I believe that we've met the burden of showing entitlement to a Frank's hearing.
Okay.
Through detective.
Okay, I understand now. Okay, all right, I get it.
I apologize for not being clear.
No, I'm sorry, it's me. Go ahead.
If the court doesn't have any further questions about Frank's, I'll
I know.
move back to Detective Dia. I want to start with something that Ms. Stifler said, which was that law enforcement struggles with cloud data. That's not what I heard Detective Dia say. It's quite the opposite. What he said is what I just said to the court. It was very clear. Law enforcement knows that they can get targeted information from these iCloud companies. They can ask for it, they can receive it. He explained the file systems to the court. Not only that, but even if they get a data dump, which he said sometimes they do, even when they ask for something narrow, they get something really big. He and his team, through their forensic software, knows how to narrow that all the way down by search term, by the person sending and receiving, by keyword, by file type. They're not struggling with this information, Your Honor. They know how to do it. So I don't think that we are in a situation where this is impossible or impractical. Detective Padilla said that filtering process takes a couple of seconds. And he also told this court that even after they filter and give it to the investigative team to look at and make meaning of, that original data still exists. It's still available. So if law enforcement, the investigative team, looks at that filtered data and they then find probable cause to get more information from that cloud-based account, from that cell phone, from that Google account, guess what? They can go back to that magistrate and say, now we have probable cause for a wider data range, for more file systems, for more information.
Yes.
What we're hearing today is that we should just be able to turn that information over. This court should just agree that even if there isn't probable cause, even if the warrant isn't particularized, and even though Detective Padilla and his team knows that they have the ability to narrow in, we should just turn it all over to the case team and let them go through it. And there's another really important thing that Detective Padilla said today, Your Honor.
And that was that when you turn that information over, and I wrote it down, he said, we can look at whatever is there. And I asked him, you can look at this type of file, that type of file, pictures, everything. He said, yeah, we can look at everything. And that's what happened here. Despite the knowledge and the capability to narrow, the magistrate was never presented that information. And we have warrants here that are far broader than the probable cause for this vast amount of information to be able to rifle through Ms. Gardner's entire digital life. And it certainly isn't particularized. I disagree with Ms. Stifler's characterization of both McCall and of Demon's DEM, ONS, and we're pronouncing it slightly differently. In McCall, the district court, in fact, did find that that warrant violated the Fourth Amendment. And that is the case about the poker game where the poker game wasn't going correctly and then there was an armed robbery. And in that case, the law enforcement did in fact get the entire iCloud account. And the court said that's way too much. And then in fact, when the state appealed, the government appealed to the 11th Circuit, the state conceded that it was overbroad. And the 11th Circuit assumed that there wasn't probable cause because it was so overbroad. This isn't a case where the 11th Circuit simply said a temporal limit of any type is sufficient. That's not the holding of McCall.
Go, girl.
The holding of McCall is that the temporal limit has to still be tethered to the probable cause determination. What do I mean by that? We have the element requirement and we have the nexus requirement. And the time limit has to make sense. What that means in this case is that there is a time limit in the iCloud warrant. However, it's not tethered to anything meaningful, it's arbitrary. And that's where we see in the Demons case that the court said that's not enough. There has to be a meaningful limitation here. We don't have that in this instance. And the iPhone warrant, Your Honor, does not have any sort of temporal limitation. Finally, Your Honor, if we are talking about being able to look through somebody's entire device or entire iCloud account, Ms. Stifler said that indicia of identification is always relevant, meaning that that should be a skeleton key to look through every single piece of information. That is not what the law allows. To paraphrase the Supreme Court in Perpetuity v. United States, the court there said, it certainly doesn't take a very creative law enforcement officer to think for any excuse to be able to look through every single file in somebody's digital life. The court there also noted that the average iPhone, this isn't like searching somebody's house, where it's a narrow scope of information. This is like searching warehouses filled with data. And giving law enforcement the permission to look through everything within the entire warehouse, when perhaps all they're looking for is somebody's car keys. And we know today from Detective Padilla that they have the ability to narrow that scope as much as the law requires. Still preserving their ability, if they develop appropriate probable cause, to go back and zoom right back out and get more information. So what we are asking this court to do today, Your Honor, is to grant Ms. Gardner's motion to suppress the iPhone warrant, the iCloud warrant, and the Google warrant, both because they lack sufficient probable cause and because they are not particularized. And this certainly is not a case where we should be discussing good faith, given Detective Padilla's testimony here today. Should the court want to entertain parsing the warrant, which I think is what Ms. Stifler has requested, we're happy to be heard further on what we believe would be the appropriate remedy. And unless the court has further questions.
Thank you very much. And so I'm going to take this under advisement. Do you all have a time frame that you're looking at? So I want to be responsive, but obviously there's, you'll give me a lot to look at, and I need a chance to go through it. And I do appreciate y'all's patience. I wasn't expecting that trial to interfere with today, so I apologize for that. From your perspective, what would be reasonable? And I'll try to work under those deadlines. What I'm trying to ask is, I don't know what you all are doing discovery-wise and to comply with the court order that I've put into place. Like, I want to be able to not interfere with your ability to prepare and be responsive so that you all can kind of know the landscape.
The state has no restrictions for the Wiretap. Probably it takes your honor to review what we provided in the right orders, suspicion of state is not going to be, at least my oversight, my ability to do the trial.
So I'm otherwise kind of occupied next week. I want to give it to you.
So you're gonna file written orders? So I don't know that we need to come back if we get usurp the orders. I was gonna suggest June 23rd, because at that point, the first motion regarding DB would either be moot or be right.
So what I'm considering is that might be okay, but if there is a need to have a hearing, bring a hearing, if there's a need, like, I don't, like, to me, like, everything is not necessarily tied up. I wouldn't necessarily resolve everything with the written order, so I don't want to give it to you at a point in time where we're pushing up against August. Does that make sense? And so I'll have it out by June 1st, but I like to have a court date associated with it, so then I'll try to get out before then, so then by June 1st, we can kind of figure out where do we go from here. And then,
So we're.
what about this? I'm sorry.
Are you saying June 1st is a court date?
I think so.
Yes, right.
Just a pre-trial. And what about the issue of Mr. Dreiser?
I think, I'll speak for myself, or I think in discussions, we should have that resolved with depositions that will resolve that issue, one way or another next week, so.
So maybe June 1st too.
That
When
would,
did I pass, Mr. Fernandez?
You did, Your Honor.
that would be fine with me, and if Mr. Bryce can have a discussion, he wants, thinks he's gonna call his motion, we'll contact the court sooner than that. Is that all right with Mr. Dreiser?
Mr. Dreiser,
Yes, ma'am.
did you hear me? Like, is June 1st okay, Ms. Day?
We're out, Mr. Hill and I are out, but Ms. Day, I believe on June 1st could be there.
It's just a scheduling hearing, so,
That's fine.
and then I need to know kind of where your team's at.
With Frank's.
Right.
We'll have a better
I
idea.
don't want to get too far into June, because there's a time frame that I'm out, then I'm back. I have a lot of trials.
We'll have a better idea next week. We're deposing Detective John Monday and Tuesday.
Perfect. June 1st.
Yes, ma'am.
Okay. So, Mr. Hathaway, June 1st, both cases will be in 308.
Yes, Your Honor. 9 o'clock, Judge, or 8:30?
9.
Yes, sir.
Actually, 9:30. I'm changing for a summer schedule,
Yes,
so 9:30. Okay.
Thank you.
So thank you all very much. I appreciate y'all's hard work.
Thank you.
I don't.
Court's adjourned.
Okay. Court's adjourned. I cannot believe that she has had to. I cannot believe that she's been. I cannot believe that she did not get bail. I cannot believe that she did not get bail. These people, man. I'm sorry, but. That's some wild shit. What do you guys think? How'd it go? What do you think? Tell me what you thought. What'd you think? Dude, she called somebody to the stand that proved the defense's case. I don't understand what Stifler was doing. Like, the argument is, Your Honor, they have the ability to just, based when you preserve the material, it's like, here, go ahead, extract it. Extract it and it sits there. Okay. And then you can piece by piece to, like, you know how, like, when you're in a house and you're like, okay, I want to search the office. You know, I didn't find anything in the office, but when I was walking to the office, I found that they have a second office and have a huge, you know, so like you keep building, and that's how you normally have to do like search warrants. You just don't get the kitchen sink and then get to go through everything. It's just asinine. Like, but that's like, those are our phones now, and it's just, you don't get, because I'm gonna tell you what's gonna start happening. Why the hell would you ever have one of these? I'll tell you who would switch their policies real quick. Would be all these people. I mean, and it just doesn't make any sense. If they were premeditating and planning to do a murder, why wouldn't they be using burner phones? You know? Why wouldn't they be using burner phones? It's you can't have it both ways. They're saying that they were using burner phones after the fact, but not before. Are you people high? They knew that they would be suspect number 1 and suspect number 2, meaning, you know, right? But just because you're a suspect or you're a person of interest, it does not mean you get to just go and get fucking wiretaps on people. Like, what did you think that they were going to talk about? You cannot, that's like saying there was a car accident that happened like right in front of your face, like you're in front of your house. I'm not going to talk to my neighbor about a car accident that happened right in front of my house, and then subsequently their house. And we're over here like, yeah, man, this dude just flew into my house and just didn't hit the turn, man. He just kept going straight right in my house. We have a conversation about it, right? You do a ruse to, look at this, to arrest Henry Tenen and to see if there's any noise there. But we're leaving out little trinkets of the facts. You guys told Jeremy Ordway, hey, Henry Tenen's vehicle was used in a murder. Jeremy then told Mario that, because that, like, why wouldn't he? Like, that's a normal conversation. Okay. That's how they found out. It was from the police. They didn't find this out from them, like, talking and having conversations on their own. The police went and told Jeremy Ordway, like, hey, it was about coming, like, they took Henry's dog to him and shit like that. And that was in August. And then in July, when they met with Jeremy before the August arrest, they told him that we believe that Henry's truck was used in something. I mean, it's just, bleh. So this is what Markey thinks. I'm going to call them and say the court needs to make bailiff check mics. Number 2, it's too broad. It's like a doctor just signing a script pad and folks in office just fill out whatever they want. There you go. Yeah, that's why all those motherfuckers got high off of pills and then they pulled the pills, the pain pills, and now they're all on fucking heroin. Yeah. Mm-hmm. I blame the government. I blame the government passing out pain meds like it's fucking candy. Okay. Jenny's like, you can not get the full enchilada when the warrant is trash. You can't also, when you want to talk about common sense, also just overstepping, like, I cannot believe that they truly called in somebody that did not write the affidavit. Testify. You guys, tell me if you think this is crazy. Okay. When did they ever establish that Mario Saldana and or Shanna Gardner ever knew of the route that Jared Bridegan even drove? So, like, that's where I would start, number one, with my argument. Like, where did that come across for your affiant here? That number one is that Shanna Gardner knew the route that Jared Bridegan took home. Because remember, the kids are out of the fucking car. Okay? When you drop off your kid, they're no longer in your vehicle. So you can't ask your kid, hey, so which way did you take home? Which way did you guys come home? Well, we came home this way. Oh, which way did dad leave when he went out? How to get home? They wouldn't know that. Okay. So why wouldn't you say if you ask the kids, did your mom ever ask you that? Like, how would Shanna Gardner or Mario Saldana know the route that Jared would take home? Because they're trying to say that there's a couple different routes because the wife that, his current wife said that. Listen to this. When I said that they used the statements of the little girl, your affiant spoke with blank. She advised that the victim called her just after dropping off the twins at Gardner's residence. She stated that he did not mention anything odd about the evening or having any disputes with individuals. This was just seconds before the shooting. That's not true. In fact, the wife Jared was like in La La Land, she said. He like was quiet and not responding. And then like we just got off the phone because they had like a 3-way phone call after he dropped off the twins with her, meaning his current wife, and his brother. Okay. Then they say, due to the specifics of the murder, such as blocking the road with a tire, walking up from the rear of the vehicle. Where are you getting that from? The little girl. That's not on camera. Walking up from the rear of the vehicle. The slow calculated shots. What? They were all in like succession. Lack of evidence of an attempted burglary or theft, and no known road rage or other disputes prior to the homicide. That's actually not true either. There's a witness that came forward that said that he heard at the baseball fields that the guy that got shot was in road rage, blah, blah, blah. So, like, they did talk about that. Like, that's a lie. Your affiant believes this was a targeted ambush. I don't give a fuck what you believe. What does the evidence say? What are the facts? Okay, you believe it's a targeted ambush. It was learned that the victim took the same route home as a matter of routine. Oh, it was? Who'd you learn that from? The only people who would have been aware of his route home would have been his current wife, Gardner, and Gardner's husband. How the fuck would Gardner and Gardner's husband know that? His route home. Did that come up in the investigation? And no, it didn't. Because you would say how. They don't even say that the twins would know that, who were like older, you know? Blank advisory affidavit that the victim went through. So his current wife said, hey, they went through a really disagreeable divorce in 2015 with Gardner. Kirsten Brightigan advised that Gardner had constantly kept the victim in court in an effort to gain, full custody and all that. She further explained that that's great that she says that, but you have to actually go and get the court filing. And when you get the court filing, you're going to see that it's the opposite, actually. Jared left. Jared left and went to Utah. She further explained that Gardner's new husband, Fernandez Saldana, challenged the victim on several occasions, such as standing at the end of their driveway with his hands folded in an aggressive posture. Fernandez Saldana also came to the door and confronted the victim at his residence when it was stated in the decree plan to text when they arrive at each other's residence to pick up the twins. Just so we're clear, that's not accurate. Your affiant interviewed Mario Saldana during his interview. He stated that he enjoyed confrontation with the victim and bragged about it. Do you guys really think that that's what occurred in a recorded interview? He didn't say anything like it. Do you want to know what the argument was for the state in this? They're like, well, that was his interpretation. Wait, since when is somebody's interpretation of somebody speaking words to you that you can just interpret that behind however you want? Your affiant also learned that Blank was starting to favor living with her dad and showed an interest in getting baptized into the LDS church, of which the victim was a member and Gardner was opposed. That's actually categorically false. That's so wrong. Like, that's not even true. That is on its, it can't be any more opposite. So when you're writing all this up, like, this is what's getting you probable cause, is Detective John's writing these statements. Then he says, a review of military records revealed that Fernandez Saldana was a drill instructor in the U.S. Army and took small arms training, among other firearms training. Everybody that goes to the military does that. Just saying. Your affiant had the twins sent for interviews with the child protection team. Your affiant also interviewed Gardner and noted several inconsistencies between the statements of Gardner, Fernandez Saldana, and the children. During Gardner's interview, she said that Fernandez Saldana only met the victim one time. However, he recounted meeting the victim on several occasions, such as during gymnastics training, school events, and at his residence. That's not how it was said. On the evening of the murder, Fernandez Saldana stated that he took a large dose of gabapentin for leg pain and was asleep on the couch. He stated he never spoke to the twins when they came home since he was asleep and they went upstairs. He stated he then got up and went to take a shower. This was corroborated by Gardner. However, during interviews performed by the child protection team, the twins both stated that they believed Fernandez Saldana was in the other room playing video games. But it appeared neither actually saw him. That's actually not true either. The one kid was like, yeah, I heard him saying fire, 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 and I saw him with his remote. Again, I have no idea. Fernandez Saldana also stated that when The twins arrived home from date night. They used the keypad on the front door or came in through the garage. Like he couldn't to sit here and say like, and it's like, well, I thought you were sleeping on the couch, you know? And it's like, well, during the course of the interview, was he simply relaying what had then been talked about? Because they came back that night, the night of the murder, the cops came over to their house like at midnight at 1 o'clock in the morning and wanting to see stuff. So, but anyways, these are where the lies are that she's going to have to sort through, because these are the fluff pieces that are leading up to this 51-page affidavit to get this shit. Anyways, we'll see you on the next one. Thank you guys. Peace out.